Namaste and greetings. I, Nikita Bhardwaj, researcher at IMPRI, Impact and Policy Research Institute, Prabhav एवं नीति अनुसंधान संस्थान नई दिल्ली, extend my warmest welcome to you all to IMPRI #Web Policy Learning. Today, we are gathered here for day 13 of Law and Public Policy Youth Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course and internship program. This program is organized by IMPRI, Impact and Policy Research Institute, New Delhi. The chair for the program is Professor Vibhuti Patel, visiting distinguished professor at IMPRI, and the fellowship lead advisor and expert legal hands-on sessions is Advocate Dr. Shalu Nigam, visiting senior fellow IMPRI. The distinguished experts include Shri Sandeep Chachra, Professor Vibhuti Patel, Advocate Dr. Shalu Nigam, Advocate Dr. Vahida Nainar, Professor Mukul Ashar, Professor Uday Shankar, Shri Udit Mishra, Dr. Nivedita P. Haran, Shri Bhartendra Singh Baswan, Dr. Purnima Chauhan, Advocate Dr. Albertina Almeida, Dr. Gladstone Xavier, Professor Aruna Roy, Advocate Audrey de Mello, Dr. Kaustav K. Bandyopadhyay, Advocate Mrinalini Deshmukh, Professor Sharmila Guge, Advocate Flavia Agnes, Dr. Rashmi Singh, Mr. Debadityo Sinha, Professor Swaran Singh, Advocate Lara Jasani, Professor Anil K. Gupta, Justice Ajit K. Singh, Mr. Himanshu Shekhar, Dr. Amar Jasani, Dr. Soumyadeep Chattopadhyay, Mr. Bilal Khan, Shri Rajiv Ranjan Singh, Shri Tikender Singh Panwar, Shri Shailesh Gandhi, Dr. Simi Mehta, Advocate Abdul Hafiz Gandhi, Professor Amita Singh, Dr. Ajay Gudavarti, Shri Amit Dubey, Professor Sanghamitra Acharya, Dr. Y. Suresh Reddy, Advocate Sanchita N. Shri Surendranath Tripathi. The conveners for this course are Dr. Simi Mehta, CEO and Editorial Director at IMPRI, Advocate Dr. Shalu Nigam, Visiting Senior Fellow at IMPRI, and Dr. Arjun Kumar, Director at IMPRI. I welcome you all to this enlightening deliberation and thank you for putting your time and energy into truly understanding the vital role of complex intricacies of legal and public policy frameworks. The course will enable the participants to comprehend the nuances and technicalities of legal and public policy paradigms and therefore acquire theoretical insights along with technical skills to conduct research. We have also shared the course outline and reading resources document in your email for your kind perusal. We will be providing videos of each session for flexible learning at your place and pace. Before we start today's session, I would like to announce the housekeeping rules. It is imperative that you join the meeting on time. There will be a Q&A session after each presentation. Share your questions in the Q&A box and not in the chat box. The questions must not be posted as an anonymous attendee. Ensure that your questions are precise. Refrain from making general comments in the question to save time. Our session for day 13 will cover topics of environment, laws, and public policy by Mr. Debadityo Sinha, foreign policy by Professor Swaran Singh, legal hands-on session 5 by Advocate Dr. Shalu Nigam. To start with the session, I would like to invite Professor Vibhuti Patel for her opening chair remarks. Professor Vibhuti Patel, over to you.
Thank you, Nikita, and welcome Dr. Debadityo Sinha and Professor Swaran Singh and esteemed participants. First of all, I would like to offer my thanks to Dr. Arjun Kumar, Dr. Shrimi Mehta, Dr. Shalu Nigam, Ms. Sweta Shankar, Ms. Vithita Satyam Tripathi, and Nikita for their hard work in putting this very exhaustive course together. We have now, and we are entering into the 5th week of and the 13th session, and previous 12 sessions have focused on the relationship of laws and the public policies, importance of judicial activism and participatory action research, evidence-based policy formulation, the role of the urban governance structures and systems, the question of the social movement, how it has shaped the political agenda, what kind of judicial activism which is desirable for the country, for the developmental issues, a question of series of new laws that we had from 1977 till the date in terms of social sector initiative, in terms of forest law, tribal people's right to food, right to work, right to education. And we also discussed the whole systems of the criminal justice system, how does it function? And Dr. Shalu Nigam's hands-on session and the interactive sessions in which we had used she had also used audiovisual media, posters, poetry, and also the processes of dealing with the criminal justice system and the legal system and deconstruction of several important laws. Albertina's experience of getting involved in both the Prevention of Sexual Harassment Act. The first initiative came from Goa, and also the Goa Special Children's Act, and the processes that were involved in terms of research, in terms of lobbying, in terms of advocacy, and the currently hotly debated issue of Uniform Civil Code, about which Albertina also spoke on the basis of Goa Civil Code, and Advocate Flavia Agnes, she gave a very inspiring talk on women's rights and legislative demands, where she analyzed the relationship of law, society, and gender with regards to implementation of reforms in the rape law in 1980 after Supreme Court judgment on Mathura rape case, and the amendments in the Indian Evidence Act after Nirbhaya gang rape tragedy in 2013, amendments in the Dowry Prohibition Act in 1961, Protection of Women from Domestic Violence Act 2005, and controversy around Section 498A, which was introduced in the year 1983 to protect the married women from being subjected to cruelty. She stated that due to pressure from anti-rape movement and punishment of rape increased up to 7.5 years, and in aggravated rape cases up to 10 years. The laws on gender issues have become strict, but the cases are not filed adequately. Burma Committee's recommendations have two-track approach to consent against her will and also without her consent. This doesn't require physical resistance. Advocate Flavia said that marital rape must be criminalized. Husband has no right to have sex with his wife without her consent. An exception for husband must be taken out under Section 376 of rape law. She also said that it is not easy to access the legal services. Rape survivors face unsurmountable difficulties and challenges at higher level. Negative judgments set bad precedent and wipe out the efforts. And also primary task is to change the mindset of the judges. The activists asked for stringent punishment, but they don't pay attention to the processes of access to justice. And for cases of domestic violence, as per the DV Act, you don't need lawyer to fight a case. You as a citizen, as a neighbor, as a family member can also fight the case. She emphasized on divorced wives' rights over matrimonial property, which is now currently debated in the context of debate or discourses on Uniform Civil Code and gender just family laws. And she discussed the petition of Majlis on division of matrimonial property, retrieval of dowry, ownership of matrimonial home, and women's rights in husband's share of Hindu undivided property. While commenting on the current debate on Uniform Civil Code initiated by 22nd Law Commission of India, Advocate Flavius also stated that personal laws have a lot of discrimination. They are feudal in nature and treat women as subordinate. She told the 21st Law Commission report contains comprehensive suggestions for ending discrimination, giving economic rights to women, while opposing the imposition of Uniform Civil Code. The current move of the state marked by one law, one nation theory is very problematic. It is not about women's rights. It is a communal agenda for the coming election. That's what Advocate Flavia felt. Naturally, the minorities are afraid. Majlis has collected signature on the petition from informed consent, informed people, the signatures of the informed people who are legal experts, social scientists, retired judges, feminist activists, and they have been already submitted to Law Commission day before yesterday. The Constitution of India has recognized tribal communities in India under Schedule 5 of the Constitution. Hence, the tribes recognized by Constitution are known as scheduled tribes, and they are around 645 distinct tribes in our country, and they follow customary laws. So without serious public debate, to foist UCC, Uniform Civil Code, will be detrimental to women's rights. And this is the highlight of Advocate Flavia's lecture. And now today we have Dr. Debadityo Sinha, Dr. Swaran Singh, and Advocate Shalu Nigam to give us more insights into the question of environmental law and public policy, and also foreign policy. Thank you.
Thank you, ma'am. Next up, we have Mr. Debadityo Sinha, who will be taking up the session on the topic Environment, Laws and Public Policy. Mr. Debadityo Sinha is the leader of Climate and Ecosystems at Vidhi Center for Legal Policy, New Delhi. Welcome, sir, and over to you.
Thank you, Nikita. And thank you. I want to thank IMPRI for inviting me for this talk. And so there's a slide which I want to share. So maybe you can put that slide on. Yeah. So you can share the slide. I'm just beginning talking about it. So environmental law as a subject is very diverse, and it is very difficult to give a lecture on this subject because it affects every other law. So although you consider certain legislations as a part of environmental law, but it is beyond that. And in this talk, I will try to explain what is environmental law and how it is different than any other law like corporate law or tax law or criminal law or any other civil law. So, and there are also intersections between all these different legal and policy systems. How it has evolved. It is very interesting to also understand how the environmental laws has evolved in the country. So I also focus a majority of my talk on the evolution part of it. Can you go to next slide? Yeah. So yeah. So basically, I will talk about how the environmental law has evolved, not only in India but globally, because environmental laws in India are affected by 3-4 different factors. One is, of course, the international agreements and meetings, and India has been at the forefront of environmental law. Although implementation has been a very challenging, and given we are one of the most populous country in the world, and we are not even developed country, but still developing. And still, I think in terms of enacting legislations, India has done a great job. It is one of the few countries which has institutions like National Green Tribunal and all those things are there. So, and as you all know, that Air Act and Water Act are the first environmental legislations which came. And if you see the history of the environmental laws, then clearly it was all need-based kind of thing. So when we felt a need, we brought a law. And ideally, what happens is first there should be a policy, and to execute the policy, you bring laws and all this thing. But in India, it has happened in a very different way. That we first brought the laws and then we brought the policies, and there has been a lot of to and fro because every government is 5 years they have term. So the political agendas, the inspiration of the country, influence of the global corporations, so it all plays a very important role. And of course, the culture, local culture and customs. So these are very important part of any law as such. So this EP Act, Incorporation Act, is one of the very major turning point in the history of environmental law, and why I will come to it during my talk. That why Incorporation Act is called the umbrella law. There is a reason behind it. It's a very short law, but how it became umbrella law, and right now I think it is used everywhere. Green clearances. So you must have been have heard about environment clearances, forest clearances, wildlife clearances. So what are these green clearances? What is NGT, National Green Tribunal? So all this thing I will just touch upon because I think it is not a legal a class of law that you have to become a lawyer and you have to practice. It is just an introduction and clearing the basic concepts of environmental law. And I think whatever work you do, so you can use these kind of concepts, and you should be aware of at least these basic things in environmental law. And last, I will talk about the challenges, drawing inspiration from the environmental principles and other things, some ground experiences. So yeah, we may go to next slide. Yeah. Yeah. So as I spoke just a few minutes ago, that environmental law is not a single law. So the beauty of environmental law is that it is very vast. Okay. So we have so many laws. If I start counting, then maybe hundreds of laws are there. There are so many acts. There are rules to the acts. Now there are also notifications under those acts, which we call as subordinate legislations, like EI notification and e-waste rules, plastic rules. They are all less subordinate legislation. So they are not act in themselves, but they are rules or notifications under that particular parent act. So, and we have separate law, like we have Environmental Protection Act, we have Forest Rights Act, we have Forest Conservation Act, we have Indian Forest Act, we have Wildlife Protection Act, we have Biodiversity Act. So there are so many acts. We have Public Liability Insurance Act. So I will come to it later on. And all the environmental law, you see, they are transdisciplinary because they are not purely environmental law. So they affect each other, every other law. It affects the corporate law, it affects the criminal law. So environmental law, if you see any legislation, it has every component. It has the economic component, it has the trade component, commerce component, it has everything. So it's very difficult to say that it is a single law. It is a cluster of different laws and which affects everything, and often it has overriding effect on other laws. Okay, it is one of the law which has temporal dimension, because see, any act, if you see criminal act or any other like taxation or anything, they are like very reactionary kind of law. And I think this is one of the challenge when we drafted environmental law, because environmental law is more about talking about precautions, that you should not do this work because it may affect the environment, it may affect adversely after 10 years, 20 years, something like that. We talk about our generations also. So, so environmental law is very unique because it has temporal dimension. So it recognizes that, we have to prevent. The focus has been always on the prevention. So compared to other laws, which are always like, if you violate, then you have to do this thing. If you go and you go to jail. Of course, these components are there, but the focus on environmental law is on the prevention part of it. So this makes it very interesting thing. And you have to have knowledge about each and every aspects of environmental law. How industry functions, what are the different chemicals, or what if a species get extinct, then what will have impact on the other ecosystem. So these kind of things it's a very scientific and economic exercise. Other thing is that it's not just a purely human rights. It's not a purely anthropocentric. So it draws from inspiration that we are part of the whole environment and everything is linked. And that's why I say that environmental law needs to be ecocentric. Although right now, we somehow like recognizes that every other living being is everything important, but in the ocean of all other law, environmental law is also like being implemented as a very anthropocentric. For example, if you see any judgment or any MGT also, so suppose there is a industrial disaster or something, so we hardly talk about biodiversity loss. We only talk about the compensation for the affected people. So what about the biodiversity, what the forest? So these things are there in the constitution and in the law, but we hardly exercise those things. But the basic, the true nature of the environmental law should be ecocentric. So this is one thing. And the modern environmental law is very recent. So why I say modern? Because it's not the environmental law has not been there in the country like before. So if you go to a religious scriptures and everything, there has been some component environmental law, whether you take Quran or whether you take Bible or whether you take our Hindu different things. So there are always some component. Even during pre-colonial times also, there are examples where kings used to exercise jurisdiction about polluting of water or pumping interest of water, control resources, control on the forest. All these things were there before. But I think all the modern laws did draw inspiration from the European laws. So what we see as a modern environmental law are very recent. I think it is not wrong to say it's hardly 50 years old. And I will come to it why it is very recent. So modern environmental law is very recent. And in India, it's not just only the international institutions, but also social movement. So if you see initially like this Tehri Dam and Bhopal gas tragedy, and so all these issues played a very important role. There was a public demand for environmental law, and it was more seen as more a part of a human rights and a social justice part of thing. So as such, there was not a distinction between environmental justice and social justice. It was always being seen as a part of the human rights and social justice. So that's why I say that it has remained anthropocentric. So there has been hardly I think there has been phases of sporadic phases where the government has been very inclined to protect wildlife and forest, maybe during Indira Gandhi time, maybe during some other minister's time, but otherwise the focus has always been human-centric. But although international commitments as the major driving force and the judiciary. So judiciary at one point of time in 90s was very activistic, and they actually driven the whole environmental law regime, forcing the government to respond. There was a time when Indian economy was liberating, and we were inviting more foreign funding and all these things. So that was also a requirement of the government to put some laws in place. And it's not a law means that you will prevent it. So very pragmatic. If you take a view, then laws are made to support industries. This is my own understanding that because suppose someone is investing money in a country, they don't want trouble. They don't want huge protest to stall their work. So you bring a law and you set up courts and you give assurance to people that see everything will be heard. But in my personal opinion, I haven't come across maybe very rarely 1 or 2 cases in the last 30, 40 years when people have actually got any good relief in environmental matters. Otherwise, it is all law and very less on implementation. So it is one challenge I will discuss later on. And lastly, very interestingly, you have to understand that issues like water, forests, they were all in wildlife. They were in state lists first. In constitution, we have state list, union list, concurrent list. That means the lawmaking power of that particular thing should be with that state or center or both. So in case of environmental law, so it was resources for all this forest and wildlife were initially with the state, but it was eventually being brought in concurrent list when we had all these laws, because implementation would have been difficult if the lawmaking power was not in the center. So if you see environmental laws, most of the environmental laws are like central government make the law, but the management and execution should be always the state. This is how the nature of the law should be. But increasingly, we are seeing that center and state, there's a constant touch between them that who is going to control, because resource in the present time, 50 years ago, it may be not that much important, but now, as we are shortage of land and everything, so resource is something which also influence the overall country's economic growth as well as political funding. So there is a very great role of political economy in shaping the environmental law, and we are seeing in recent times that environmental laws are being diluted left and center wherever, irrespective of the political party in the power. So it is like, and everywhere in the world. So it is not like only to India. I think this is the natural way to evolve. Any species, they want to dominate, they want to eat up the resources as much as they want. So this is one thing. Can you go to next slide? So yeah, so there are certain guiding principles in environmental regulations. Now this is very important, and you have to understand this thing, the whole environmental regulations around the globe, in the India, wherever. So this is the crux of it. That there's one thing is for mitigation hierarchy. So it basically says that any activity, the first thing should be avoidance. For example, you want to dig a mine of coal. So it should not be that I want to dig a mine of coal, so I should dig a coal mine. The thinking should be whether I can avoid mining coal and I can have some better alternative, which has least environmental impact. This is the one thing where we should start with. First is whether we need that kind of mine, whether there is other alternative of source of energy, and if there's no alternative, whether we can you cannot avoid, then minimize. Minimize means whether we can do it in a way that it will not affect the environment in an adverse way. So first from avoidance, then comes minimization, and then if there is impact which is you have to do it. There is no other way. So suppose people are dying of a drought and you have to build a dam, that is requirement. Then of course you have to build the dam, and of course there is some cost to it. So you have to accept those costs, but the overall benefit of that particular site should be outweigh the damage caused. And it should not be just made because we want to show some GDP numbers, or we want to just have like kind of feel good factor that, in my district there's a big dam, in my district there's a big mall. So it's not like that. It should always be a need based, and it should be justifiable, and it should always follow this avoidance and minimization. And if by chance you have to do it, then the focus should be restoration. And restoration, not that I cut 10 trees and I plant 100 trees. It should not be like that. You should try to restore the whole ecosystem. This is the one thing. And lastly, if you can't do any of this, okay, then you should offset it. Offset means like, you do this exercise in some other way, like not the same place, some other place, or you monetarily compensate the affected people like that. So this should be the last resort. But what we see usually, we do the opposite. So we just, while we prepare a project, we say this is the amount of compensation for people, this is that, and then we just start with the notion. So with the political approval. So ideally, should be the way how you should proceed with any activity if you are concerned about environment. Other thing is that I think you all have studied in some point of time in your life, in your school or colleges, anything. So one is the precautionary principle. And that means that if there is some activity which has uncertainty, like if I do this activity, there is a chance that, for example, someone gives you a glass of water, you're thirsty. And you are looking for pilgrims like here and there, and then you saw one river flowing, and then you think that this river is receiving industrial effluent. Okay, it may be pure water, but I don't know. So whether I will drink that water. Okay, so I will not drink. I will prefer looking for some other thing. So precaution principle is like that. That if there's enough scientific uncertainty that this activity can cause some damage, then you should not do it. So it's precaution principle. The principle is like that. Often the judges and the policymakers confuse between precaution principle and principle of system development. So precaution principle is based on the fact that you should not proceed the activity when the impact you don't know. Okay. System development is that, okay, fine, I should proceed with the activity, but I will take care that, I will not exhaust the resources to the extent that it will devoid any other person or generation from the same benefit. This is the system development. There's a thing called public trust doctrine. It is very important, and our constitution also recognizes this thing. That simply means that our government is a trustee of the natural resource. They are not owner of it. Okay, so the natural resources, forest or wildlife or river or any common land, so government should preserve them in the public trust. So like it should not be owned by anyone. It should not be licensed to for commercial purpose. It is like you trust the government to keep natural resources safe. But eventually it happened in other way. So now we see that government is itself promoting giving out land and diluting laws. So this is one of the doctrine you should know. Other thing is that polluter pays principle, like someone pollutes, then he has to pay. It should be the last resort, as I said, the mitigation hierarchy, but often it becomes pay and pollute. There's a thing called principle of strict liability, which is then colonial law. It simply means that suppose there's some accident and someone lose their life or there's some property damage, then the person should be liable to compensate for the loss. For example, I build my house and I by chance during earthquake my house fell on some other person, the person died. So strict liability says that in case of such acts which is beyond my control, suppose there's a act of God like earthquake, then I am not liable, okay, because it is beyond my control. But if I didn't construct the house well, I use inferior quality of materials and then the house fell on someone, then I am liable to be prosecuted. But Indian judiciary has evolved this principle, and we take a lot of pride, and India is the first country to introduce this term called absolute liability. So absolute liability is that irrespective of anything, okay, suppose I'm doing some activity which is of commercial nature or some other nature, whatever, and there is some damage to some property or life, and it is specifically used in case of hazardous chemicals, hazardous industries, specifically hazardous industries. So I am well aware that if there's an accident, there's act of God, then this will cause human damage or property environment damage. So that's why all these exceptions like earthquake or flood or something like that, some other miscreants, whatever, those excuses will not be entertained. So basically the person will be prosecuted irrespective of any other thing. So there's no exception. If I'm doing any activities which is environmentally harmful, I know it will cause environmental harm when there's accident or something, then I should be absolutely liable. So they should not say that, it is beyond my control. Someone, some miscreant came and he broke my pipe, and that fire hazardous waste flow into the river. So this kind of things are not there. So this absolute liability is a new concept which the Indian judiciary has coined, and we use in many all the laws now. All the environmental law, even the National Green Tribunal Act, it mentions that you have to decide the compensation based on absolute liability. But we have often seen the judges uses on the older strict liability. Now there's the last thing, it's called principle of non-regression. It is also used in a way recent times when the governments try to dilute the environmental laws. So the principle says that any protectionist law like environmental law, they should be only improved, okay, because they have larger public interest and all these things, so they should not be diluted. So if you dilute any or weaken the safeguard through the amendment in the law, and then it will be against the principle of non-regression. So these 5-6 principles are the basic foundation of any environmental law. Last thing I will want everyone to read and go download and read is this report of UNEP. It came around in 2018 or 19. Just Google it. So it's a very interesting report, and UNEP report on this environmental rule of law. So I think it's a Bible of environmental law, and it is drafted in such a manner that anyone can be able to read and make sense of it. It is not a purely legal document, but it sets the stage as how a country should frame their environmental laws. It sets the basic principles. Okay, it's the guiding document for any environmental law, and I think this report you must definitely read. This is one reading material I want to suggest you before going to anywhere else. This is the one report you should definitely read. So can you go to next slide? So I think time is less, so I will just quickly go through this revolution part. So yeah, so if you see most of the environmental laws in India, they are enacted after 1972. So 70s actually. The trigger was this Stockholm summit. You all know about it. So basically, when globally there was some consciousness that the environmental issues are getting prevalent, and there has been so much impact which was visible, like pollution and loss of biodiversity, loss of forests, all this thing. So all the country leaders, they decided to meet and think and manage those crises before it becomes unmanageable. I think in 50 years we have already now in a different region, but it's important to know the precursor of that thing. So we came up with a thing called Stockholm Declaration. It was those 26 principles that all the countries must be follow. And there was a global understanding, we have to halt this environmental degradation. And UNEP was constituted to guide different countries at national level, international level, so all this thing. And it was given a time that after 10 years, we'll again meet and we'll take a stock and we'll do things whatever we want. But within 10 years was a short time, and between that there were so many conventions, like the convention on international trade of invasive species, the convention on, I think, on this CFC's Kyoto Protocol, Montreal Protocol. All these things was there were many commissions, which was conventions which was happening that time. So there's so much happening that we just decided that it is, and there was also constant turf between the developing and developing countries. So developing countries were scared because they were on the most of countries were just independent, they're a very young country and they wanted to develop. And by that time, US and other countries were very developed. European countries were quite developed country, and it was seen as a ploy to hold development of other countries. And it was a global understanding that right to development is also a human right, and we should be not stopping it. So there was turf. So that's why what happened was the countries, they say that before we meet, we should have a strong document that what is the way forward and to settle things. So basically, there was a commission which was formed by the same group of people. It was called World Commission on Environment and Development. And if you see the first meeting, it was called Human Environment. In the second, when this 83, this report was formed, it was called Environment and Development. So this evolution you can see, Human Environment to Environment Development. And Brundtland Commission, the same, because I think the head of the Norway country was named Brundtland. She headed the commission, so this name Brundtland Commission came. And first time this term, Principle of Sustainable Development, was coined in this book, in this report, which was called Our Common Future. So it was said that we should not be compromising with our development, but we should be careful that we don't do this thing beyond unsustainable manner, and it should be sustainable, that a future generation should be able to do it. So it was compromised with the original, decision to arrest and manage the vessels. It was like a win-win situation for everyone. So that point of time, everyone accepted this thing. Can you go to next slide? Yeah, so 92, we had this Rio Conference on Environment Development. So, and this time, not only head of states, but the scientists and civil society was also invited, because it was realized that they are going to play an important role in their country. And in Rio Declaration, we had some 27 principles in environmental governance. So, and we had action plan for next 10 years, because we realized that nothing happened in the last 20 years, all talk, no walk. So it was called Agenda 21 as action plan for next 10 years. And we had some non-binding, legal binding like principles, which were called authoritative principles for conservation management. So which all the countries should be like trying to implement in their own laws and policies. But there were two important legally binding agreements. One was this United Nations Framework Convention on Climate Change. One was this CBD, Convention on Biological Diversity, which is still date, it is existing. And I think most of the countries, I think 190 or 200 countries agreed to this agreement. So it was a very good, successful in terms of the agreements and all this thing. Then there has been several conventions, as with the previous thing, that sustainable development, global creators. So there were many Kyoto Protocol. So Kyoto Protocol was 1987. So we had a target to reduce emissions of GHG. We have many things like that. Can go to next slide. Next slide, please. Yeah. So since 92 and after like 10 years, we had again this World Summit on Sustainable Development. Now again, see the change in term. First the human environment, then environment development, now sustainable development. So until date, none of the targets were reached, were achieved. And initially, like countries like US and Europe, who were at the forefront, they also started showing less interest. Because they were also scared that their development might be affected, and because countries like India and China, they were emerging as an economy after the all this thing. So they were also quite scared, and there was a Cold War kind of situation where countries were not very happy accepting, because they had their own personal their own promises to the country they are from. So these kind of things were there, but this time they also invited the industries. So the first meeting, there was only the country heads. The second meeting, they had scientists and civil society, but now they also invited industries. And now we have this term called green economic growth. Okay. So you see the evolution of the environmental law. So it has been diluted every decades. And for next 10 years, nothing happened. And we said, okay, fine, we will have a meeting called Rio Plus 20. So that meeting happened, but उसमें कुछ हुआ नहीं उस meeting में. And by that time, we didn't have any fancy name. So it was just Rio 92, so was plus 20, but 20 years later on. So if you see all the meetings of COP after that, we got 21, 26, it is just like 20 years from the Rio, 21 years from the this time. This kind of things started happening. So this is one thing. So in 2015, we had United Nations Development Summit in New York. There was the 17 Sustainable Development Goals. So the Millennium Development Goal was only for till 2000, and after that we have this SDGs. So the target was to reach by 2030. We have the major agreement in the Paris Agreement, which was legally binding, and it was in 2015. It was political agreement, but there was no obligations on the prescribed goals. So basically, the countries should be doing on their own nationally determined contributions by 2020, and the focus should be to limit the global warming below 2 degrees Celsius. Okay, and this time we realized that 10-year cycle is not working, so we should we should have 5-year cycle to remind ourselves and take stock of things which is not happening. This thing, so this happened, and Kyoto Protocol was dissolved, and this indices were brought in, and now it is used everywhere. This is the thing. Just a minute. So yeah. So and 2021 we had this COP26, and we all know what happened in COP26. It was first meeting after the COVID time, because COVID time didn't honi paya. So we had this meeting after 1 year, and we called it COP26. So the focus was on finance, climate finance. Everything came down to the money ultimately, and nothing significant come, but there was a disagreement on the phasing out of coal. And this term, it became quite a news that India and China, at the last moment, they decided to not agree with the phase out, but phase down. That means that we will be continuing with the fossil fuel emission. And this time, 2021, we had this thing called ratio mechanism. So ratio mechanism means that this national determined contributions should be revised every 5 years. Okay, so this is like about this thing where we are right now. So, and right now we all know climate crisis is happening. In last 2-3 years, we have extreme weather events every year. So there's no doubt that climate change is happening. So last 50 years, this whole international agreements, they all have been only talks, nothing happened on ground, and we are here. So we're going to go to next slide. So environmental laws in India. So basically, you have to understand there are three major kind of law. One is the common law, which is not a statute written, but it is a customs, and like somehow when there's no law, so basically you follow customs, the traditions, customs, and what the court says. So in common law, judges play a common law. For example, law of public nuisance is a common law. Now, civil law is something which is written by a statute. That means the government has made a law by the parliament. When parliament makes a law, then it's called a civil law. Okay, so and criminal law is something. So a civil law is basically how you should behave in a society. Okay, so this is a civil law, how you should your daily affairs. You should like to maintain law and order. Criminal law is civil law defines your individual behavior, but criminal law is something where the state initiate action for maintaining law and order. For example, some activity which has larger public threat, so then it becomes criminal law. So basically, criminal means the person is threat to the society. Okay, but suppose I have a fight with my neighbor. Okay, it's a very personal fight, or it is some white collar crime. So these are civil law. Okay, most of them. Criminal law is become when some activity the person becomes so dangerous to society. So civil law can become criminal prosecuted when the activity is dangerous to the larger society at all. So that is the main difference between civil law and criminal law. Most of the civil environmental law is under civil law. They are not under criminal law. And the thing is, there are two different school of thoughts. One says that environmental law should be criminalized, and there are criminal provisions in the environmental law. But there are different school of law which thought which says that environmental law should not be criminalized because there is no immediate death and life, something like that. So it's a very complex arguments, and personally, I think it should be a mix of both. If there is an activity which is you're deriving profit from some activity, and you're threatening people and some people die, then obviously it should be criminally prosecuted. But I think in recent time, this Jan Vishwas bill was introduced by the parliament, and it was passed eventually. So the focus is on decriminalizing environmental law. So I think you should know this thing. So the focus in past 1 or 2 years has been on decriminalizing environmental law, and it's a mixed kind of reaction from everyone. And we have published enough literature on that. I personally have published one research on this decriminalization environmental law. You can find out with his website. But other than that, natural resource law, if you see the management and control of natural resources follows our eminent domain, which is the British time we have been following, that the state has complete control and authority, and we have limited rights. For example, I have land. So eventually land is with the state. Okay, the state has given the land to you for some purpose, and state can anytime take away from you. This is something which is following from the colonial law. And land and everything should be on natural resource law. So if you see all our laws, so they have become they follow somehow the eminent domain. The state has a complete control. Okay, so can you go to the next slide? I think time is running out, so I should use hurry up. So just to quickly summarize the evolution of environmental law. So first we had the national. So basically we didn't have any Ministry of Environment Forest separately. It was under Food and Agriculture Ministry, all the environment forests, and we have Department of Science and Technology. So forests were under the Food and Agriculture, and the other environmental matters were under the Department of Science and Technology. Okay, so this National Council for Environment Policy and Planning was there under DST. But later on, when we had this Stockholm was, I think, the trigger, and that time we had political will to do this thing. So we established Ministry of Environment Forest in 1995. As I told you, we amended the constitution to also introduce the constitutional duty on the citizens to protect environment and wildlife in 1976. Because the time India was independent, environmental issues were not that much pollution, climate change, not even people even thought of this kind of things. but they become important part in the next 3 decades that, we have to make it explicitly mentioned in the constitution that is the duty of the state and citizens to protect the environment, and thereby there becomes a public trust doctrine a state has to protect. We had our 7th amendment constitution and 92, where we say that why only state and center, why not the third pillar of the democracy, the local government and Gram Sabha and municipalities. So they should be given the power to play a role in lawmaking and implementation. So this 11th and 12th schedule, this amendment was brought, and if you see all the environmental laws, they follow this thing only on the paper. Mostly it is the state and the center which is managing it, but it is obligation on the government to, so in every law you will see there is some role of the municipality, but we haven't done much to enhance their capacity. So things are the same on the ground. It is more actually worse now, to be fair. We had our first environmental policy in 1992, and the National Environmental Program was formed in 1993 after Bhopal gas tragedy, and these judgments were given. So that was something the time when it's been 78 and 92, there was all these laws were being formulated, policies were being formulated. India is an experiment phase of environmental law. Can you go to next slide? So it's important to mention the role of Supreme Court from 1990s. So basically the principle of absolute liability I told you. So it was first used in oleum gas leak case, but it was triggered by the Bhopal gas tragedy. What happened was Bhopal gas tragedy and oleum gas leak case both were just 1 year apart, and both cases were being heard by the same judges. And just I think few months before oleum gas leak case judgment was come, the judgment of oleum gas leak came before the Bhopal gas tragedy, and that time oleum gas case it was the second incident after the Bhopal gas, and it created a huge public uproar. And so Supreme Court came up with this absolute liability term because strict liability was hindrance to justice, because they say it's accident, it's an act of God, whatever. So they said, no, we are coining this term absolute liability and you should be liable to be prosecuted. So it was Shriram gas leak case in Delhi. And it was used, the same principle used in Bhopal gas tragedy as well. And that time we also brought this law called Public Liability Insurance Act. It is still dated on in force. So basically it says that any industry, they have to take a insurance under this thing, and they have to submit some money to the insurance company and the environment relief fund. So any accident happens, so the immediate relief should come from environment relief fund and then insurance. So we had done a report on this PLI Act, Managing Environment Relief Fund. I published that as it was first report. So I tracked for last 3 decades what happened. I found that not a single money has been awarded from the ERF for any industrial damages. It's not in the accident didn't happen, but it shows the implementation gap. Like we had a law of 1991 until 2020, there was not a single money being spent from that relief fund. We had this forest law. It is a whole different subject, and it's beyond my control to explain forest law in this presentation. But it flows from 1865 from British time, and till date, as of now, we have 3 or 4 legislation. One is the Indian Forest Act 1927. We have this Forest Conservation Act 1980, and we have the FRA Forest Rights Act. But till presently, we don't have definition of forest, and that is the center of all the debates. Supreme Court has played an important role in the defining forest, and also established Central Environment Committee, which monitors the implementation of Forest Conservation Act. All these policy under policy 1990s, the Delhi CNG, all this thing, many things like they are driven by the Supreme Court, even thermal emissions, firecrackers ban. So things where government fails when there's a larger public interest, then Supreme Court steps in. Then we have this entirely separate court for called National Green Tribunal. It's not right to say court. It functions like a court, but it's a quasi-judicial body. It's a tribunal, but it's a very special tribunal because the appeal of NGT has to go to the Supreme Court, and it has its roots in the international agreement of Rio and other agreements. So it was an obligation of India to have this kind of body, and I will come to NGT later on. And we have ecosystems, yes, there's some wildlife corridors, like it also Supreme Court, like because Supreme Court, these both institutions like National Green Tribunal and ESZs were like being evicted. Can I go to next slide? Yeah. So this is just major like environmental laws. So just to summarize it. So it's nothing special, but it's just to summarize. You can just go through it once. How environmental laws has come to India. And it is a central law, but there are many state legislations. So in the Forest Act also, there is a state version of it. There are rules to it, so everything is there. You can go to next slide, I think. Yeah, so I should definitely talk about the Water Permission Water Act because it was the first environmental legislation in independent India, which talked about controlling the pollution, and it was primarily because of the increasing water pollution, because water pollution is visible, and River Ganga and all these rivers were getting polluted. We were suffering from a huge issue of waterborne diseases that time. So, and there was a need to brought something. So Water Act was the first law. Why it is important, because it established these pollution control boards, like Central Pollution Control Board and State Pollution Control Board, which still exist today. And we use a concept called consent to establish, consent to operate. So basically, if you want to establish an industry which has some water discharge, then you have to first take consent to establish that I intend to establish industry, and so the SPCB will give a permission. And after you establish the industry, you have to put your safeguards in place, and only after then you will give a consent to operate. It's not like you give one permission. There's two layers of protection. First, when you are planning. Second, when you are operating stage. So this is very part of it. And till date we are following it. But now we're talking about single window clearance, all these clearances. But that time, I think this thing has at least arrested what we could have seen a much more damaging kind of thing. So that is one thing. And also mandate the industry and local bodies to discharge domestic sewage only after treating them. Okay, so not without treating. And we have to also establish the appellate authority. So suppose someone is affected by some other licenses, they can always appeal to the authority. This kind of grievance redressal mechanism also established. I think it was beautiful decision given at that point of time, in 1974, when we had no background to learn from. So it was very ambitious and very courageous kind of thing. It took a huge kind of political will to brought this law, and it was still late active. After we brought this Air Prevention Control Pollution Act, after near about 7 to 8 years, and it follows the same structure of PCBs, SPCBs. One thing important is that it also gave the power of the pollution boards to declare some area as air pollution control areas. That means you can declare particular area as a control area where you can have a separate emission norms. Okay, you can control industries. So this kind of things were evolved at that time. And go to next slide. Next slide, please. Yeah. So now EP Act. So it is very important act because it is a very short act. It is very if you read the EP Act, it is a very small and very simply written act, but it was brought as a reaction to the Bhopal gas tragedy, 84. And it was also one of the commitment of the Stockholm to bring an overarching law, because Air Act, Water Act were very specifically for the water pollution, and it was more like creating standards for it. It was the larger environment question was not addressed by those. So we thought that we need a law which can be used to control anything and everything. Okay, and you should have enough scope to intervene, enough powers. So basically, it was created in a very hurry. And that was a very short 26 sections, and if you see the EP Act, then you will see there are prescribed to be prescribed by central government, everything it's a bit prescriptive kind of thing. So everything has to come through rules and regulation later on. Okay, so as such, EP Act if you see, is only talks about powers of the central government and the state, and what is the objective of the act, but it doesn't say more than that. It didn't even create any institution out of it. Okay, so just enabling framework that law is there. Law means you have to follow. It's the law of the land. Now center and state can conveniently bring law, but the intention at that point of time was control the pollution, not dilute the law. That point of time. So if you see, initially EP Act was used to bring strong environmental legislations. Okay, that was the main part of it. And the important part is that all the rules under this act, it has to go through the parliamentary scrutiny. It's not like it doesn't have a parliamentary scrutiny. You have to go to parliament for any rules. That is, you have to go. And any rule or notification under this law will have the same status as that under the act itself. So it is this kind of law, the thing. So that's why it's called umbrella law. So I think under EPI there are thousands of notifications rules. So if you start counting, there are many.
Hello, Dr. Debadityo.
Yeah.
Can you just wrap up in 2 minutes? Because our next speaker is waiting.
Yeah. So I was given 45 minutes, so I will just finish with my time. Yeah, please. Can you go to next slide? Yeah. So this EP Act, as I told you, so I think these are some examples of the rules and notifications about this. So yeah, and the interesting part is that under EP Act, you can also bring notifications. So basically, central government can also notify a land as a control zone. So for example, it cannot like this Aravali ecosensitive zone as an area. That means that you can restrict industry activity in that zone. So this EP Act is also used to notify areas as a special economic zone, ecosensitive zone, and notification zone. Like this kind of things are used. Can you go to next slide? Yeah. Now the green clearances. So for development activities. So I think under EP Act, we have this CI notification 2006 and CI notification 2019. So basically, any activity, if you want to, which has potential environmental actors, so there is schedule to EI notification. So all those kinds of industrial activities, they need permission under EI notification 2006. And this is for environmental clearance. So basically, there are project category A and B. So they are both given by the so category A projects are given by the central government and category B given by the state governments. Okay, CRZ means the coastal regulation zone. So basically, if you want to do any activity in the coastal region, then you have to take permission under the CRZ. It follows the same mechanism as the EI notification. You have to take forest clearance under Forest Conservation Act. So basically, when you want to divert any forest for non-forest activities, then definitely you have to take permissions from the central government. So that's what we call forest clearance. If you want to do any activity within a wildlife sanctuary, national park, or any corridor, so tiger reserve, then you have to take permission from National Board of Wildlife, and that's also central government. And there is State Board of Wildlife as well. But the decision-making power is the National Board of Wildlife. It's for wildlife clearances. Consent I already discussed. In 2006, we recognized that it is injustice to the people who are dependent on the forest, who are living in the forest for generations, to not have their say in any development activities. So when you want to divert any forest, definitely you have to take, because I told you that we amended the constitution in 75 amendment that local government will be given importance in the decision-making power. So that's why this Forest Rights Act also was introduced. And if it's not forest, even the trees anywhere outside the forest, then before cutting the tree, you have to take permission from the state. So Trees Act is that different from the Forest Act. This is one thing. Can you go to next slide? Yeah. So I think we can skip this. It's too detailed. Can you go to next slide? You can skip this part. Yeah. Go to next slide. You can also skip this. I already discussed this in the last slide. Yeah. So NGT, I think this is the towards the last section. I just want to talk something about the NGT because this was a very new code issued in 2010, and it has three main jurisdictions. Section 14 is the by jurisdiction. That means it has original jurisdiction over all civil cases where there's substantial question relating to environment. That means anything which affects the environment adversely, you can go to the NGT. And it's not every matter, though. Basically, there is a schedule which is given to the Act, and the all the different acts like Environment Protection Act, Forest Conservation Act, not wildlife, but I think Public Liability Insurance Act. There's 4 or 5 acts are written under which you can go to NGT. It's the appellate authority of those acts. It also has special jurisdiction for providing relief and compensation to victims of environmental pollution or any kind of accidents. Last, appellate jurisdiction. That means Section 16, if you are affected by any order passed by the government, then you can challenge those orders in the National Green Tribunal. So these 3 jurisdictional entities there. Can you go to next slide? Yeah, this is schedule of the NGT. So all these 7 acts, if you have any complaint, you can go to NGT. And all these orders under this act, all this under jurisdiction, you can appeal to the NGT. Okay. So I think we should move ahead. Time is less. Yeah, this is my last slide. So what many challenges of environmental law is that it is more like a reactionary system, not a very proactive. So you see the evolution and everything, even the implementation is very reactionary. We hardly follow the mitigation hierarchy as I explained. Avoid is minimize, restore, and offset. It's not followed. Implementation is greatly compromised because we don't have the state and the central don't invest much in the capacity building or resources or the independence of the institutions. So they are still working under the same system. So basically that also hinders the implementation. And if you see, most of the environmental laws are very old and outdated. So they were drafted in 70s, some in 1920s, and we have amended them, but it didn't catch up with the changing dimensions of the environmental law and the needs of the society. And lately, it's been seen as a roadblock to the industrial and infrastructure developments. That is one thing where laws are like always seen as a anti-development kind of thing. It's sensitive to political regime. I already, and special, I told about this thing. Existing the penalties and all these things, they are not deterrents to polluters. So even like when it decriminalizes it also, so they're happy to pay the amount and pay and pollute. That kind of situations there. Very poor set of grievance and remedial mechanism system. So because environmental damages are have temporal dimension, so you have to have a very proactive and time-sensitive system to address those grievances. But our system is very slow, and we often have irreparable and irreversible damage already caused to the environment. So this is something. And increasingly, I think there is a reliance on the court. So most of the environment matters, they go to the court ultimately, and nothing happens after that. So this is one thing. And last slide, please. Yeah, and you can reach out to me, social media, or you can also email to me. And I don't know if time is there, but I will be happy to take questions. But yeah, I leave it to the organizers. Yeah.
Thank you, sir. Thank you, sir, for such an enlightening and insightful session. We are running short of time, so if possible, please answer the questions in the Q&A box. And we'll move to the next speaker. We have Professor Swaran Singh, who will be taking a session on the topic foreign policy. Professor Swaran Singh is the professor and chairperson at Center for International Politics, Organization and Disarmament at Jawaharlal Nehru University based in New Delhi. Welcome, sir, and over to you.
Thank you. I'm happy to see that we are not wasting any time, and I hope you can hear me and see me clearly.
Yes, sir.
And we can start. Thank you. We can start right away. First of all, my thanks to Impact and Policy Research Institute, especially to my old student, Dr. Simi Mehta, who I know is now the CEO and editorial director of IMPRI. Thanks also to the chair, Professor Patel, who's on my screen. I can see her. And thank you to other people who are joining the program. I see we have about 23 people listed on the screen. After that very, very impressive, shall I say, roller coaster ride on environmental laws that Dr. Sinha was just sharing with you, let me assure you that I will be rather relaxed. I have no PowerPoint. I'll make few points. And any of you, I understand you come from a whole variety of backgrounds, may not be really students of international relations or foreign policy. So I will be talking very generic issues that determine foreign policy and India's foreign policy. And I hope that makes some contributions to the fellows who are doing this Law and Public Policy Youth Fellowship Program of IMPRI. And therefore, to make sure that you have a takeaway, I will encourage you to intervene at any stage and raise your questions or make your comments, so that fundamentally idea is that about 45 minutes that we will spend together, me and all of you, there should be some takeaway. You should feel you learned something. So let's begin with that perspective and understand, first of all, why foreign policy is important, first of all, to be listed as one of the topics for you to understand. We today live in times where we are talking of time and space shrink. World is so deeply interconnected, so deeply interdependent that you are constantly in real-time engagement and interaction with people around the world. Early modern times, European nations had devised things like longitudes, latitudes, time zones, altitudes, because those parameters were relevant at that time. For example, if somebody sitting in Paris had to instruct a commander to start a war in Algeria, they were in different time zones. So how will you explain to the field commander what time, what action has to be taken? They require time zones. Today, we don't need. We are constantly connected with each other around the world, thanks to technology. Now, once we are connected that deeply, that means the old-fashioned division of nation states that almost about 50 years back were in full control of their people. I, as a young boy, started when we had to apply for permission to buy a transistor radio. Today, you can connect to any part of the world. You can listen to any radio from any radio station around the world simply on your mobile phone. States today are finding it difficult to deal with how people are connected, what they are sharing, what they are talking. So much empowerment of people in that sense. And because people are connected, businesses are connected, in ancient times, only precious commodities were exported from one country to another country. Now, even your toothpaste, your bananas, your apples, everything you use can be exported and imported from around the world. So fundamentally, the intertwining of international society is so rapid and so influential that states must keep aware of what is going on. And possible, if it is, then at least give some direction to where their people are going, what their people are doing with other people, what their businesses are doing with other businesses, what their artists are doing with other artists. That is where foreign policy, which was earlier only a domain of one ministry, and when the whole process of diplomacy and foreign policy began, there was a joke that king would normally send someone as an ambassador abroad because he didn't like his face in the court. So if you didn't like someone, send him far away as an ambassador. But now, foreign policy is something that every one of us are doing. Commerce Ministry has its own foreign policy, Sports Ministry has its foreign policy, Education Ministry has foreign policy, even universities have foreign policy. They have their own partnerships with other universities. So the connections between each of the nations with the rest of the world are so deep and influential and wide that foreign policy has become everybody's activity. Some of you may have friends around the world on your Facebook, on your Twitter, on your Instagram. So important responsibility of Ministry of Foreign Affairs now is not just to conduct foreign relations, but also keep aware of where rest of the country is going, whether it is sports ministry or it is sports organization or it is a university or it is a business house. Provide a broad direction. That is the most important activity now foreign ministry does in terms of foreign policy. Provide a broad bandwidth or a direction for India's engagements with the rest of the world. Engagements at all levels. Sports people, academics, media people, everybody. So foreign policy and foreign ministry have to provide that direction. In what direction are we going? Second important task is to facilitate people who are connecting with the rest of the world. Task of Ministry of Foreign Affairs is to conduct foreign policy and diplomacy such that each one of us at all different levels, when we engage other nations and other counterparts of ours in other nations, that activity becomes productive and takes India as a nation forward. So foreign policy, it seems, is not limited to foreign ministry now. Foreign policy is something that all of us are doing all the time. And therefore, it is significant for all of you to have some basic understanding of what makes a foreign policy effective or ineffective, what makes a success story, what makes other foreign policy not a success story, what makes the foreign policy, first of all. So we can talk about what typically in our class to students we say determinants of foreign policy. It is not free choice of any leader or any nation to, okay, this is what I want to do. There are limitations. So there are determinants that determine what kind of foreign policy is possible and what kind of foreign policy is not possible. Then among the determinants, the most important is leverages. See, if you want, see, the fundamental task of foreign policy is also to create international environment such in which India's voice, India's vision becomes far more effective, far more easy to understand, far more attractive for other nations to engage with. So create environment such that it is like simple example, if I'm a cricketer and you are a footballer and we want to play a common game, I would like you to play cricket because I'm playing cricket, I'm good at cricket, right? But when you start playing cricket, you may not be as good player in cricket. So then I will have advantage. Likewise, for example, democracy has become fashionable around the world. So United States is most powerful democracy. They go around the world, sometimes they attack other nations to establish democracy. So they want to make sure that everyone should try to become democratic. And when everyone tries to become democratic, then country that is already democratic has an advantage because you're trying to be like them. So likewise, each nation has some of the leverages, as we say. There are some special, for example, if you are a tall student, then you will find it easy to touch things which are higher. For example, if your friend is not tall and he's trying to take a book from the top shelf in library, you have leverage. You can help your friend to take that book out of the top shelf and give it to your friend. Now, your friend is now obliged. Likewise in nations. When nations have leverages where they can be helpful to others, other nations have to listen to this nation now. So leverages are what is the fundamental power of any nation to use that in diplomacy to achieve goals of foreign policy. Then there are also, of course, important role of leadership. Now I mentioned world is in a time and space shrink. We are so close to each other. We are so available to each other all the time. So when diplomacy began some 300 years ago in modern fashion of nation states, they had to appoint ambassadors as plenipotentiaries. They were called plenipotentiaries because they could also take decisions on behalf of state. Today, the ambassador only implements the decisions of the state. He doesn't take decisions. But then because these ambassadors were far away, it will take 6 months for him to send message to the emperor. So plenipotentiary ambassadors were allowed to also take decisions because it was not easy for nations to meet each other very easily. They used to travel on horseback, on carts, until industrial revolution happened. And today, very quickly, let me jump to saying, we live in a state where summit diplomacy is very fashionable. Leaders, national leaders meet each other very frequently. For example, Indian Prime Minister will meet, let us give, for example, French President, who Indian Prime Minister is now traveling this week to France. But Indian Prime Minister has met French President in many multilateral forums. He was recently in Japan, where there was a G7 meeting, group of 7, the most advanced countries. Indian Prime Minister was invited there as a special invitee. France was member country there. So they meet so regularly with each other because now we live in era of summit diplomacy. So that makes leaders' role very relevant. If your leader is not very effective, very articulate, very smart, then even if nation is smart, it will not be as useful. Your nation may be very empowered, very capable, but if leader is not very smart, very articulate, very driven, full of energy, so leadership role, and it is not just one leader, Prime Minister, it is leadership in totality. Your foreign minister, your commerce minister, your senior bureaucrats, your diplomats, your ambassadors all over the world. Leadership also plays a very important. So we are saying fundamentally, there are things like leverages and leadership that will determine whether we will have opportunities that will become challenges or challenges will become opportunities. What will be leverages? Whether we will become liability or we will become leverages. We will be useful to others or will be a country that others want to avoid. Now, once we know what are our advantages and disadvantages, what are our strengths and limitations, then we decide aims and objectives. Right? then we know I can aim to do this. For example, some of you aim to become civil servant, some of you want to become lawyer, some of you want to become businessman, because you think you're good at it. You know what are your assets, what are your skill sets. Likewise, nations also, depending on their leverages, leadership, and of course, several other things that we will discuss, determine what are the aims and objectives of foreign policy. Now, the first thing that is significant in making of foreign policy is population. You know, I often tell people in my class, 19th century, small countries of Europe became very powerful nations because they had naval fleets. So discovery of steam engine led to discovery of naval fleets, and small nations of Europe became so powerful, they went and occupied whole of the world. They became imperial powers. So in international relations, we had to devise a term called great powers. In 20th century, we had nuclear revolution. So countries that had thousands of nuclear weapons, they were called superpowers. United States and Soviet Union, now Russia, they were called superpowers. Great powers were countries that could influence events around the world. Superpowers were countries that could influence events around the world at multiple places simultaneously. In 21st century, the key to national power is people. If people are skillful, healthier, educated, productive, they are going to be source of national strength. In 19th century, I mentioned even smaller nations could become powerful around the world. Not possible today. And when you talk of population, India today is world's largest population country. Remember, India today is world's largest population country. We have about 4 million Indians living in United States alone. There are several nations who do not have population of 4 million. We have only Indians living in United States. Sometimes I joke that population of the size of Hong Kong or New Zealand, that number is the number of Indians sitting on airports to board their flights right now as I talk to you. About 7 million people. So population is very significant. How large or how small is your country? Because then only you can engage the world. Our population, that is why you see Indian foreign policy now focuses on engaging diaspora. Indian people, wherever Indian Prime Minister goes or Foreign Minister goes, they engage Indian community very clearly because they are now the ambassadors of India. So much so, lately we are also focusing on Indian soldiers. See, British used large number of Indian soldiers. 1 million in First World War, 2 million in Second World War, to fight wars in Europe, for Britain. So Indian soldiers contributed to fighting wars and making peace in Middle East, in Europe, in Africa, because they were fighting colonial wars of Great Britain. Now we want to remind the world that Indian soldiers were fighting at so many places trying to establish peace. Equally closely related is territory. How big is your country? India is world's 7th largest country. That matters. Because if you're some tiny country, maybe many people outside your country do not even know where is this country. If I was to name few countries like Burkina Faso, Saint Kitts, I don't know how many of you know where this country is. But if I say United States, I'm sure all of you know where United States is. So the size of population and size of your territory is very significant in how you can engage with the rest of the world, because that will determine your foreign policy. Then, of course, location. Where are you located? Are you landlocked, as we say? You have no access to oceans. Because if you have access to oceans, it is easy to relate to the world. You can send your ships wherever you want to go. 90+% of world trade happens through oceans. So you can be a trading power if you have access to oceans. So you can see how long is the coastline of India. Just imagine India's map. India jets out into Indian Ocean. In fact, that is how it is named Indian Ocean. We have a large coastline. So that is very important strategic location for India, because we can engage with the world by sending our ships wherever we want. We have open access to ocean. And on the north, we have Himalayas, which also is a great barrier for any other country to invade us, influence us. And you see, India has very small, tiny countries in its neighborhood, which makes India look like very large and powerful and influential. So strategic location, where are you located? What size is your territory? What size is your population? And then, of course, India is also continuing ancient civilization. Not every country can boast it. All these European countries at best are about 1,000 years old. United States about 300 plus years old. Of course, if you include the indigenous history of Indians in America, American Indians, that's a longer history, but the current United States, people who call themselves Americans, they are about 300 years old. So ancient civilization, but also ancient continuing civilization is very significant, because that gives you enormous knowledge base. Your traditions, your ancient epics, your great books, your great sages, your great kings, that whole experience of 5,000 years of history again makes India very unique. For example, India is so comfortable with diversity. You have heard something called unity in diversity. So in India, we celebrate diversity. All of you are so comfortable. If somebody next to you is speaking language which is not your own, you are fine with it, because you're used to listening to many languages. In your school, in your colleges, there are classmates who speak different languages, eat different food, sometimes wear different kinds of clothes, they have different preferences. It's okay. We are a multicultural society in that sense. That also is advantage, because when you deal with the rest of the world, you meet new people. Your diplomats from childhood are trained to deal with different kinds of people. They are very fine. They are at home talking to different kinds of people, eating with them, going out with them, negotiating with them, because we are multicultural within. And that is inherent. You don't have to train that to a diplomat. In some cases, when you're only one ethnic community, one religion, one language, that is something that would then need training to deal with a whole range of different people. So we are talking of population, territory, and history. This is very significant. Then we come to liberation movement. How was India as we know today was established? Was this country established through a violent revolution? Then your foreign policy will be different. Or was this country established through peaceful transfer? See, British imperialism was very powerful and very brilliant, because they were good for themselves. Compared to some other European small countries that went out and colonized, Britain had a very smart strategy of colonizing other people. Two things. One is called divide and rule. They would try to create divisions among people who they colonize, so that those people will never feel powerful and united enough to throw out these colonial powers. Second, they always promised piecemeal empowerment of people. I have just sent to my hosts my recent speech at Indian Council of World Affairs on making of India's foreign policy. I hope they can share that document with all the fellows in this program, and you can read about short 4 pages write-up of my speech at Indian Council of World Affairs on Indian foreign policy. So you can also read that, how Indian foreign policy was made. So liberation movement also created, for example, there were a lot of cooperation of India's liberation movement with other countries. Subhash Bose, for example, was connecting with Germany, with Japan. Some other revolutionaries were connecting with China, with Hong Kong, with Southeast Asian countries. In India's the father of the nation, Mahatma Gandhi, had experimented first in South Africa. So even national movement was global in that sense, was connected to many other countries in close relationship. So when India became independent, it had contributed to fighting of the wars around the world. It had contributed to other national liberation movements and working with other national liberation movements. In fact, India was a founding member of United Nations before India became independent. Now that was possible because British were doing piecemeal transfer of power, not transfer of power at one go, but gradually. Many acts, 1858 Act, 1909 Act, 1919 Act, 1935 Act, many acts were made by British to gradually do this peaceful transfer of power. So nature of national liberation movement again is very significant to making of foreign policy. Then let us jump to, I see my clock is moving, contemporary times. India today is seen as a very attractive country for everyone to become partner and friend, to engage with and build relationship. Why? Because India is not just world's largest population country, India is also a young population country. Youth bulge. So Prime Minister of India talks of demographic dividend and democratic dividend. India is largest democracy, but India is also largest population country, young population country. Largest population country, but also largest young population country. That is why you see India is now becoming known around the world for startups. India today has more than 100 what are called startups are called unicorns. Unicorns are startups that have already obtained an investment of more than $1 billion. So imagine young people are transforming how Indian economy is looked upon and how economy is run. E-commerce is very significant. All of you, I think, are very smart. Young people are very smart with technology. So you're using online payment platforms, you're using online shopping platforms, you're using all kinds of online platforms of socializing and doing business. India today is offering other nations, for example, whether it is CoWIN portal that India had created during the pandemic, or it is online payment portals that India has built and it is sharing with other countries. Indian Prime Minister recently spoke at Shanghai Cooperation Organization saying India has created a artificial intelligence driven language base called Bhashini. We are willing to share that with the rest of the world. So digitalization is something where India is able to contribute thanks to young population, which is very driven and open to learning new things, doing new things. And of course, that results also in India being today world's fastest growing economy. Among the large 20 economies, you are hearing a lot these days about G20. India is now president of G20. India is going to host G20 summit meeting. So in that sense, India is the fastest growing economy. What it means? Any of the developed countries, companies, if they want to go out and invest, where they will go? They will go to a country where they will make better profits. It is called per dollar returns. They will have better per dollar returns if they invest in India because Indian economy is growing fast. Share market is going up. So therefore, you see combination of large population, large territory, ancient history, wisdom. That is why we are able to think of Vasudev Kutumbakam. Not every nation from the ancient times was thinking of Vasudev Kutumbakam. That world is one family. Therefore, number one aim of India's foreign policy has always been ensuring world peace. Now, this will look very idealist to you, but ensuring world peace is the only way to ensure progress and security and safety for all of us. Because we are 1.4 billion people. We are much bigger part of the world. If we are able to provide a good life for our own citizens, we are helping the world in many ways. So therefore, today, let me try to close. Let me ask Professor Patel, do students ask questions by speaking or only by writing?
They write and they also unmute and speak.
I will encourage them to speak. So let me very quickly close because I should be answering things that they want to know rather than doing my own monologue. I'm speaking, I'm old professor. I'm used to speaking. I can go on speaking forever, but I would be happy if some of them speak up and I then answer what they want to know.
Yeah.
Let me just close by saying that in this new era of India being fastest growing, large economy, very attractive, India is able to pursue a very unique policy called shifting from non-alignment to multi-alignment. That is how Indian foreign policy is known, which means India is today trying to build partnerships in as many sectors with as many countries as possible. India is buying enormous amounts of oil from Russia, but also supplying humanitarian assistance to Ukraine. They are at war with each other. India is very close friend of Saudi Arabia, of Iran, of UAE, of Israel, of Egypt. These are countries that sometimes don't talk to each other, but they're all friendly to India. That is a very unique golden mean policy. If you go back to ancient wisdom, golden mean, madhya marg, jisko kehte hain. So some kind of balancing between building these relationships where we are having a strong relationship with China, Russia and others, and also Europe and America. It's not easy because each of them would like to see India towing their line, joining their alliance partnership. But India says we are too large. We don't have to join any particular group. We are part of all groups. So that is where Indian foreign policy today is moving. It's not an easy exercise. It's not easy to make everyone happy, but because India is rising as a very powerful economy, as a very rapidly transforming society, very young population, technologies heavy young people, that is why some of these nations, even if they are not most happy because India is not following their line, they still love to engage India. United States is not happy with India's neutrality on Ukraine, but they still have to. You see how Indian Prime Minister is received when he goes to United States, or how he will be received when he's going this week to France. But they understand that, even if India is not fully agreeing to what they would like to see India doing, India is still very important for them to engage. And I think that is where Indian leadership is trying to make best use of this opportunity, which is a historic opportunity for India to emerge as a global player, if not global leader. That we can at least contribute to how global trends are determined, in what direction we want to take the world. And other than the leadership, you must understand the role of ethnic Indian community, Indian citizens. You notice how many more Indian ethnic origin people are today leading all the major global companies of United States, of Europe, of East Asia. In fact, the World Bank president for the first time is of Indian origin, ethnic. He's American citizen, but he's a person of Indian ethnicity. So visibility and contributions of Indian population around the world, Indian people around the world is constantly increasing. So let me close by saying, Indian people you see today, wherever they are in the world, they feel proud of being an Indian or proud of being an Indian origin. That is why they are so excited when Indian leaders go there. Recently, when Indian Prime Minister went to White House in the United States, you saw thousands of Indian origin people reaching the White House. Sometimes even those leaders have never had such large rallies for themselves. But when Indian Prime Minister goes there, they see such large gatherings which they have not seen themselves ever. So when Indian Prime Minister was in Sydney in Australia, Australian Prime Minister also came to join that rally where Indians were come together to meet Indian Prime Minister. He called Indian Prime Minister the boss. In G7 meeting in Japan, American President told Indian Prime Minister, "You're too famous. When you are coming to White House, I have flood of people who are trying to get invitations to join that state dinner." So he said, "Maybe I should take your autograph." It's a nice way of saying, but fundamentally it means India is becoming very visible, but also influential around the world. And that makes the responsibility and task of Indian foreign policy very, very significant, but also a very, very challenging task. For one ministry to manage that, it's not easy. And therefore, at all levels, all of us perhaps also are contributing to the making of foreign policy and implementation of foreign policy. Therefore, each one of you also need to be at least minimum aware of what is India doing in terms of engaging with the rest of the world. how each of you are part of that activity today where India is engaging with the rest of the world. Task of foreign policy, as I said, is to provide a direction and facilitate how India, all of us, 1.4 billion people, led by the leadership, facilitated by Ministry of External Affairs, can also contribute to how India can go forward in ensuring security and prosperity for us, but also for the rest of the world. Let me close here, and I would love to see that some of the students actually, if they can open their videos, I would love to see them who's asking me the question, but otherwise just unmute yourself and ask me a question. That will be easy way to communicate, and I'll feel happier that I'm answering what you want to know.
Thank you very much, sir, for such an erudite and insightful session. Firstly, I'd like to request Professor Vibhuti Patel to share her remarks.
I think, Professor Swaran Singh has really covered almost all aspects. It's extremely comprehensive and a very broad canvas that he has taken. My two queries I had. One is about at the 27 places on this planet conflicts are going on. How do you visualize India's role in peacemaking, peace building, and peacekeeping? And second one is that in what way do you see the role of parliamentary democracy and multi-party democracy in India? What message does it give to rest of the world? Because most of the countries don't have, either they have autocracy or a dictatorship. So that way, even being a developing country, how has India nurtured multi-party democracy?
Thank you, Professor Patel. Let me be short in answering so that we can have more people making comment. I think it's a brilliant question. You allow me to give little more explanation on foreign policy. In diplomacy, we talk of para-diplomacy. Para-diplomacy means where your provincial constituents, provincial units also contribute to the foreign policy making. Not every nation has bicameral legislature, meaning two houses, upper house and lower house. In lower house, it is the population that decides how many representatives of each province will go to the parliament. But in upper house, each province has more or less equal share. 2 representatives in upper house, or 3 or 1, but more or less not disproportional like in the lower house. Now, upper house in that sense is particularly privileging the provincial units to make all foreign policy or all policies of the country. So all policies have to also get approved in the upper house. So provinces have a direct contribution. That means your federal system or your confederation, we have a unitary quasi federal system here. Not only they contribute by their people electing members to the parliament, but also they themselves elect, the provinces elect members to the parliament in upper house. So they have a direct contribution to how foreign policy is made. Then, of course, in case of India, provinces have a very special role, particularly because of coalition governments, as you mentioned. In coalition governments, each of the units, each party that was making the coalition had very important role. For example, if there was a political party from West Bengal, they'll have a great role on how India's Bangladesh policy is determined. Leaders from Bihar will have a great contribution how India's Nepal policy is determined. Leaders from Punjab will have a role in how Pakistan policy is determined. Leaders likewise from Tamil Nadu will have a great role on how Sri Lankan policy of India is determined. So federal units in India have always had, and after coalition era, their role has increased much more. So in that sense, you would remember Prime Minister, when he was going through his first elections in 2014, he had created a concept called Team India, that he would create a Team India of the Prime Minister and all the chief ministers put together to determine national policies. So federation does have a role, and India creates a certain facilitation, certain institutions where they play a role in foreign policy. To your other question on 27 conflicts around the world going on, India has a standard policy of not intervening, not interfering into internal affairs of other countries. And because most of these conflicts are internal, most of them are internal civil wars. They are not interstate wars. Of course, Ukraine is an interstate war, And in that case, India is contributing. I wouldn't say intervening or interfering, but contributing, because Indian Prime Minister talks to President Zelensky, Indian Prime Minister several times talks to President Putin. Indian Prime Minister tells President Putin this era is not era of war. He goes to G7 summit in Japan and says nations should not unilaterally change territorial boundaries, but very indirectly contributing, not using coercion, because India would not like any other country to interfere in what India is doing internally or in its bilateral relations with China or Pakistan. We don't want any other country to help us how to manage relations with China or Pakistan. Likewise, India doesn't believe in contributing in terms of using any coercion or mediation, but India definitely indirectly in the forums that are available, India always raises voice to contribute to putting an early end to violence wherever it is, because non-violence is in our DNA. So that's in our ancient traditions, repeatedly articulated, including the non-violent struggle that Indian Mahatma Gandhi had. So non-violence is very integral to Indian thinking, and therefore wherever violence is, India would like to see that violence comes to an end as soon as possible, but not using the violence, not using coercion to put an end to that violence, but using only diplomacy and dialogue as much as possible. And India has been very visible in case of Ukraine crisis, trying to make sure that it can come to an early end, or at least it doesn't become really so dangerous that there's a possibility of nuclear weapons being used. So, that is a danger that is there, and India would like to make sure that we do not reach a stage where the nuclear weapons are introduced in that war. So you understand that as good as I understand that India has a certain bandwidth within which India makes contributions, and Indian foreign policy remains engaged on those issues world over. Thank you so much.
Thank you, sir. The floor is now open for questions from the audience.
Yes.
Mr. Mohammad Abdullah Hamid, who is joining us from Pakistan, would you please like to unmute and ask your questions?
Yeah, sure. At the outset, thank you so much for the session. Really enjoyed it. So I have 3 questions. I'm an avid follower of foreign policy. So, I was just slightly more enthusiastic about asking all the questions that I had. Okay, so my first question is, and I've written these in the question and answer box as well. So my first question is, does India's pursuit of a permanent seat on the United Nations Security Council align with its claims of being a champion of global peace and equality, given that it's currently embroiled in different conflict itself? Second of all, my question is, what impact does the Khalistani movement have on the relationship between the Sikh diaspora and the governments of India and other countries? And my third question is about whether both Pakistan and India are using sports exploitatively at the behest of devoiding billions of people from watching both Pakistan and India play together in a bilateral series. We both know both boards have discontinued playing bilateral series. They only engage in World Cups and trophies that involve other countries as well. Do you think that's an exercise of bad foreign policy by both countries? How do you see this? So these are my 3 questions. Thank you.
Thank you so much, and thanks for joining this program of IMPRI. Compliments to IMPRI also to be able to get people from Pakistan to join your program, because there is a usual understanding that India's foreign policy when it comes to Pakistan is explained in one line: terror and talks will not go together. But that does not mean that there is no link. There are different levels and different ways of indirect communication between 2 countries, and I'm happy that you have participants or maybe more participants from Pakistan. Let me quickly try to answer the question that you have raised now. First, about the UN seat and India being kind of engaged in certain relationships that are not necessarily peaceful, and what is India's role in sort of global peace. I think India, first of all, presents an example of having had a national liberation movement which was predominantly non-violent struggle, and therefore saw peaceful transfer of power. That itself shows India's commitment, India's trust, faith in peace as privileged motive. And that's why I mentioned the number one objective for India's foreign policy is to not just that when Indian Constitution was written in Article 51 of Directive Principles, the founding fathers of India wrote that in Constitution that India's objective will be to ensure global peace. It's in Constitution of India way back in 1940, late 1940s, when they were discussing how to make India's constitution. Of course, India has had complex relationship with the two of its neighbors, Pakistan and China. And some of the Indians even believe that if China and Pakistan were not the most allied allies of each other, then perhaps they may not be as complex a problem as they are today. Or maybe they should be seen as one problem rather than two problems. As far as the claim to UN seat is concerned, because of the credentials of a peace-loving country, the world today believes that one kind of system that is possible to have any effect on future is that this system must be representative. Whether it is the national system or it is international system, if it is not representative of people upon which it is taking decisions, then that system will not work. So United Nations was created way back, almost 75 years before, in a certain situation where the world was very different. Much of the world was still colonized. Then in 1960s, you had about 50 countries suddenly becoming independent. Today we have 200 plus countries. There were only 50 countries at that time, independent countries. Now, if countries have moved from 50 to 200 plus, then the same system cannot deliver unless it is reformed. So reform is very central requirement for credibility of United Nations. I'm not talking of credibility of India or Pakistan. If United Nations has to stay credible, has to stay effective, has to stay useful, then it must reform and become more representative. And India, being the largest democracy, definitely deserves to be given a prime seat wherever it is, whether it is UN Security Council or elsewhere. In 1960s, some reforms had happened. For example, UN Security Council was expanded to include more members because 10 were not enough, because now in 60s, 50 more countries joined as basic members of UN, and UN Security Council expanded from 10 to 15. Economic and Social Council expanded from 18 to 27, and some others like that. So now if number of members has gone up to 194, maybe these agencies at least needs to expand in their membership. Now, whether they give India a permanent seat or what they do, that's a separate matter. So first of all, reforming United Nations system is a need of United Nations rather than India. Now, whether you think India is deserving to get that seat or not is irrelevant, because India is already being engaged around the world, whether it is in the UN Security Council or outside. United States, when they want to create a quadrilateral security framework for Indo-Pacific, they take Japan, Australia, United States, and who? India. They want to create another quad. United States wants to create another quadrilateral, multilateral body in Muslim world. Remember, I'm underlining because question is from Pakistan. They are creating a quad in the Muslim world. They take who? They take Israel, UAE, US, and India. They think India is a relevant country even in Middle East. So even if India is not sitting with a permanent seat in UN Security Council, the way India is engaged around the world is very significant. I think I can take one more quick example of about 3 years back. Organization of Islamic Cooperation, which was earlier called Organization of Islamic Countries. Since the question is from Pakistan, I'm tempted to give this example. They had invited Sushma Swaraj, then Indian Foreign Minister, to speak in the plenary session. Shah Mahmood Qureshi was the foreign minister in Pakistan who told OIC, if you do that great offer to Indian foreign minister, I will not come. OIC said, very good, you make your choice. Indian foreign minister went and addressed the OIC plenary session, Organization of Islamic Cooperation. Now, why this is a significant example? Because 1967, when OIC was created, Fakhruddin Ali Ahmad, who later became president of India, led India's delegation to the opening of OIC. At that time, remember 1967, East and West Pakistan were one. Pakistan was the largest Muslim country. Zulfikar Ali Bhutto was leading the delegation from Pakistan. And he told the hosts, if Indian team is not asked to go back to India without participating in OIC's founding ceremony, I will not come out of my suite. Fakhruddin Ali Ahmad had to come back to India with his team without joining the inaugural ceremony of OIC. So India of 1967 and India of 2017 and now 2023 is very different. India doesn't need United Nations as much as United Nations needs India. Maybe I'm a little jingoistic when I say that. Second question about Khalistan. No one in the world seriously believes that Khalistan has any future. So you see, when they do certain mischief in any of these places, very next day you have a larger protest gathering holding Indian flags at the same spot, and you see a minuscule number of people who are holding those yellow flags. So I'm not denying that there are people who still believe that they have some hope, I don't know how, on Khalistan movement. Recently, some of the countries like US, UK, Canada has seen some of these people becoming visible. But I don't think anyone seriously thinks that that's a future, because right now, Punjab is not even ruled by the party which is ruling the country, it is ruled by another party. And that is the beauty of Indian Federation. You could have multiple parties ruling multiple provinces. And I don't think anyone in India feels in any doubt that Khalistan has any future. At some stage, of course, Khalistan movement also had a close relationship to Pakistan. Again, I should not rigor on that far too much, because otherwise friends from Pakistan will think I'm kind of making it too much between India and Pakistan. And finally, question of sports. Sports, academic exchanges, media exchanges are usually seen as soft cushions which nations use sometimes to begin dialogue, when dialogue is in kind of a dead end. They want to try and begin that. And I'm sure as and when India believes that, yes, they are now convinced that dialogue with Pakistan should begin, I'm sure before foreign secretaries meet, they will try to make sure that academics or media people or backdoor channels or sports people begin to meet with each other. Apparently, India has not as yet come to the conclusion that we need to begin a formal official dialogue with Pakistan. That does not mean there is no dialogue. You remember when India wanted to send humanitarian assistance to Afghanistan, there was conversation. And I must say, Pakistan also obliged. Pakistan gave land route for Indian food grains to go and reach Afghanistan. So it's not dead end in the sense of zero communications. There are communications at various levels, but let's say the official level, formal dialogue is not on. And that is an assessment that India has about certain things that India expects Pakistan to do, which would make it possible for India to engage with Pakistan. And that is not India alone. In fact, I should not be too firm with a guest from Pakistan, but there are several other countries, including your most allied ally. Nixon used to call Pakistan most allied ally. And then, of course, later, I think Reagan onwards, they were calling Pakistan the frontline state of United States. United States is kind of shrinking away, shying away from engaging Pakistan today. So therefore, India is not the only country which is saying no dialogue. I'm sure there are other nations today that also find difficulty in engaging and entertaining conversation with Pakistan. I'm sorry, I think this is going to be one-way conversation. I'm not sure if you will have a chance to respond back to me, and we don't want to make it a bilateral communication discussion here. I'm sure other people have things to say. So I wish to definitely make sure that I tried to be very academic in answering, and I hope I didn't hurt your sentiments.
Thank you so much, sir. Now we take another set of questions. Animesh ji,
Yes.
on mute.
Daruji.
Animesh ji, Daru ji.
Can I?
Yeah, go ahead.
I wanted to ask, sir, how does India approach its relationship with China. And sir, your views on India internationalizing Chinese yuan, and won't it affect India-US relationship? Uh, and so we can say India's de-dollarization move is a more pro-Chinese stance.
Okay, thank you for your question. I think you are alluding to the fact that India is using a small percentage of payments to Russia in yuan and UAE dinar. That is why you said India is internationalizing yuan. I think that is your reason to say this. Let me say, as I was explaining to my friend from Pakistan, foreign policy cannot be black and white. It has to be very nuanced, depending on how to better calibrate, better manage outcomes. So yes, India is using very limited amount of yuan to make payments to Russia. But India is not internationalizing yuan. That's a very different ballgame. India very clearly will never be a country to support internationalization of yuan. That's a broad in principle position. But when we say strategic autonomy, that means tactically we can maneuver, tactically we can take positions that are showing certain kind of accommodation, but in long run, our principles and objectives are very clear. So the only group that is talking of de-dollarization, as you mentioned, is BRICS nations. India is sitting there, and they are fundamentally focusing now on using local currencies between their bilateral trades, not the multilateral trade within BRICS, but bilateral trade within BRICS is now adding more and more amounts of local currencies to be used instead of dollar. Yes, so BRICS is a most hopeful case. Like at some stage, euro was created as a parallel currency to become, international currency, but euro couldn't replace dollar. Dollar definitely has shrunk over a period of time. For example, in last 20 years, the global reserves have come down from about 78, 79 to about 60 to 63% of the total exchange. Each nation has their own foreign exchange reserves. In that, the share of dollar has now come down to about 61 to 62%. Likewise, in international trade, dollar still is about 88% of the currency used as international currency for trading and debt repayments and debt procurements, etc., etc. So dollar is a definitely very powerful currency that gives United States an unusual advantage, because ये तो उनका तो अपना ही currency है ना, this is their own currency. They don't have to then procure foreign currency. It's their own currency. The problem now is that some of the countries are saying United States is weaponizing the dollar in punishing, for example, Russia in terms of very harsh sanctions. So that is why some of the countries in BRICS are beginning to say, let us think of creating a parallel currency, which BRICS can potentially do, but it's not an easy exercise to do. And India is not supporting yuan becoming an international currency in no way. But of course, tactical maneuvering sometimes happens. Like I'm sure you must have read about India using yuan to make payments to Russia. I hope I quickly answered your question. I think there was another people who wanted to say something, so I must listen to others also.
Ms. Shalu, please ask your question.
So my question is more towards, it's a bit sensitive topic. It's towards Islamophobia in the world. And whenever there's like at airports, there are the brown people, even if not Islamic. I'm not Muslim, but it feels very wrong when you are just picked in the random checks, as they call it. India itself says that it's secular, but I do not believe that that's the case by the party at power, given the Ramayodhya Masjid case and everything. But I'm trying to be sensitive and not trying to, but these are my honest thoughts. I want to know your opinion about how India's take is on Islamophobia, especially when the whole world is against, is trying to eliminate like Islamic people are terrorist kind of thing. What's your opinion about this?
What is my opinion about what is happening?
Yeah, what's your opinion about like Islam on the national level as well as on international level when the global politics is going
Yeah.
against
Okay,
people
I
of
got it. I will not deny that in about last 20, 30 years, the word Islamophobia has become more visible. Um, I will not deny that. There are experts, there are groups, there are people, there is media that mentions Islamophobia, both in saying that this is the problem, but also in saying that this is not the problem. So there is a narrative around Islamophobia, which let us say did not exist. If you go back 20 years, 30 years back, there was no debate about Islamophobia at that time. Now there is a debate about Islamophobia. Now, who could be the most authoritative person to speak on behalf of how India sees this problem and how India wants to manage this problem? I think only day before yesterday, I forget where he was speaking, India's National Security Advisor, Ajit Doval, I'm sure you know him. In his speech, he said, terrorism and religion has nothing to do with each other. So no specific religion can be identified as a breeding ground for terrorism. That's a authoritative statement, most recent. One can go back to earlier years also. You will find several such statements from prime ministers, from ministers, from other senior bureaucrats. So I'm just saying what was the most recent. Maybe things have changed, but as late as day before yesterday, the speech National Security Advisor mentioned that. So I think no nation and no individual in sane mind, in senses, believes that any specific religion is kind of the breeding ground for terrorism. Terrorists are fundamentally criminals. They have their own religion. Their religion is crime, terror. That is their religion. And I think common people increasingly understand that and reflect that. Yes, when you have policies made at the national level, there is always what we call erosion of that vision when it is implemented on the ground. Sometimes on the ground, things happen that are not necessarily representing the vision of national leadership. That is not necessarily representing India's DNA, India's civilizational wisdom. But that happens in all nations. All nations would have those small aberrations where things are happening that are not defensible. You can't defend those things. It is never possible to ensure all 140 crore, 1.4 billion people, including the last person, will behave in the manner that India's founding fathers had imagined India to be. That is why you remember Mahatma Gandhi used to say the policies should look at the last man in the line, the poorest of the poor. That remains responsibility of a state, that even one citizen should not be seen doing things that are not acceptable, that bring bad name to the nation. But in practical terms, that's not possible. So I understand that this debate of Islamophobia has continued, and there are people who believe that Islamophobia is a reality. Others say, no, this is not a reality. This is only a fiction. So this is an ongoing debate. I stand on the side which believes, as most Indian leaders and Indian people believe, that religion and terrorism has nothing to do with. In fact, if you remember, the instrument of terrorism as a political tool was first legitimized by Vladimir Lenin. He was not Islamic leader. He had nothing to do with Islam. He had justified terror as an instrument of undoing bourgeois and creating proletarian revolution. 1920, 21. So it's a complex thing. I think people sometimes use this for ulterior motives. When they have motives, when they already have conclusions and are looking for facts to support them, and they're not looking at the reality from facts, but they are choosing facts to justify something that they want to say, then I think they want to link religion and terrorism, but otherwise terrorism is a religion of its own in that sense, who only believe in killing innocent people without any rhyme and reason, who have nothing to do with the policies that they want to oppose. That is why we earlier used to talk of insurgencies. Insurgencies were trying to challenge establishment and harm establishment. Even guerrilla warfare beforehand, if you go to 19th century, these kind of what we call low intensity conflict, irregular warfare, you had guerrilla warfare, then you had insurgencies, now you have terrorism. Terrorism is completely disconnected from politics. They are trying to hold politicians or political leadership hostage by killing innocent people. Sorry, I'm talking perhaps too much, too vehemently, too charged perhaps on this issue, which is very complex, but very troubling also. So only I think wrong people are using terrorism, and wrong people are again talking of Islamophobia, linking it to religion. No sensible people link it to any religion. I think terrorism is a global problem. It's a problem for all religions. We all know all religions talk of good behavior, good things. Why would any religion promote killing of innocents? So at least in my understanding, both my own understanding and my understanding of India's policy, state policy, and I quoted the National Security Advisor to begin with, I don't think India relates terrorism to any religion. I hope I answered your question more directly than you asked. You were very cautious and nuanced in the way you asked it, but I think I was trying to be a little more direct about it. Thank you.
Thank you, sir, for taking up all the questions very elaborately. We'll move forward with the next session for the day.
Thank you so much for giving me extra time, because I started about 20 minutes late and I think I'm 25 minutes late now. So the derailment of, in fact, we always say a small delay is a sign of good debate. Too much delay is bad, of course. Thank you very much. I must thank all of you for asking your very brilliant questions, and for the host to invite me to speak to all of you. God bless you and have great life yourself. Be safe and enjoy your life.
Thank you so much, sir.
Moving forward, we have Advocate Dr. Shalu Nigam, who will be taking the legal hands-on session. Advocate Dr. Shalu Nigam is the visiting senior fellow, IMPRI, advocate, author, and researcher, gender and human rights. Welcome, ma'am, and over to you.
We have very interesting sessions today. So, and we have exceeded our time. So very quickly, I'll just go through, these slides. Yeah, so we'll talk about, we have listened to, the whole, the history of environmental laws, and, but I'm taking a slightly different perspective, because we are talking about, free market economy, globalization, and, all other things like, Make in India and other kind of projects. But have we learned our lessons on environmental disasters, and what is still left to be learned? So I'll take you back in the history. On December 3, 1984, the Bhopal disaster, as the earlier speaker has already he mentioned. So this tragedy, this was an accident which took place in the night of 2 to 3 December 1984. And the Union Carbide India Limited, they have a plant in Bhopal, Madhya Pradesh, and over 50,000 people around the plants were exposed to a highly toxic gas called methyl isocyanate. And many people died, and many people are still, suffering the consequences of it. But the estimate of death toll varies. In 2006, affidavit by the state that the leak caused, so many injuries, more than 5 lakhs of injuries, and 38,000 temporal or partial injuries, and several of the people were permanently disabled. In 2008, the Madhya Pradesh government paid compensation to only 3,787 victims who were killed due to gas leak, and to slightly above 57,000 of injured victims were paid compensation. And but there are estimates which says that more than 8,000 died within 2 weeks, and another 8,000 have died due to diseases which occurred due to this leakage. So lawyers, academics, and journalists, they have described this disaster as an ecocide. So the owner of the factory was, it was majorly owned by Union Carbide Corporation of the United States. So when we talk about globalization, we talk about, the one country, trading with another country. So, this happened at that point of time. And this company later was owned by Dow Chemicals. And civil and criminal cases were filed both at the United States and in India. And this was against the chief executive officer of the UCC at that time, Mr. Warren Anderson. In many of the cases, between 1986 to 2012, in US court were dismissed, and in India, they say the US court says that since this company is a Indian entity, so they will not entertain the case. But some of the courts have given decisions. So civil and criminal cases were also filed in the courts of Bhopal, and which involves UCC, the Indian part, and the Chief Executive Officer Warren Anderson. In June 2010, 7 Indian nationals who were the employees in 1984, including the chairman, the Indian chairman, the person who was of Indian origin, they were convicted in Bhopal of causing death, negligence, and they were sentenced to 2 years of imprisonment and fine of $2,000 each. Now, all were released on bail shortly after the verdict, and but there were a lot of studies have been conducted after that, and some of the reports says that safety regulations were not followed by the company. They were malfunctioning, and many of the valves and walls and the lines were in poor condition, and gas leakage was reported earlier too. Thousands of people had died the following morning, and the primary causes of death were choking, collapse, and pulmonary edema. And the lungs, kidneys, and the livers, all those parts have been affected. Some people suffered from cancer, blindness, loss of livelihood, and because a lot of money has been gone into medical treatment, so people suffered from financial strains also. The healthcare system immediately become overloaded. In the severely affected area, nearly 70% were unqualified doctors. Because of a medical system was not equipped at that point of time, and they were not prepared for thousands of casualties which were coming to the hospitals. And many of the doctors and the hospitals were not aware of the proper treatment and the methods of, how when this gas is inhaled, what kind of treatment should be given. So there were mass funerals, there were mass cremations, and within a few days, even the environment is being affected. The tree in the vicinity become barren, and even animals were also affected. So many people were treated at hospitals, dispensaries, and even the buffaloes and goats and other animals were also being affected. The fishing was prohibited because of even the water was affected, and the food supply became scarce because the suppliers fear that if they go, they will also suffer consequences. So the government of India passed the Bhopal Gas Leak Disaster Act in March 1985 that gave the government right to represent all the victims. The UCC, as usual, absolved itself from the situation, and the company's response to the accident was that what a professor of environmental studies says, that they describe as a campaign of erasure. Like they say, okay, no, it's not our part, like nothing has happened. So on 17 April 1985, one of the federal district court judge in US, J.F. Keenan, he suggested that because of fundamental human decency, the Union Carbide should provide $5 to $10 million and should immediately help the injured. And he suggested that the money could be quickly distributed through International Red Cross. And UCC say that, okay, since this doesn't constitute an admission of liability, and they can credit this figure toward any future settlement, so they offer $5 million relief within 2 days. The Indian government turned down the offer, and in May 1986, the litigation was transferred to the court in India. because they say that it is an Indian entity managed by the Indian citizens. So the Indian Supreme Court told the both sides to come to an agreement in 1998 November, and eventually an out-of-court settlement was agreed, and Union Carbide agreed to pay $470 million for the damage caused in this disaster. And through 1990, the Supreme Court heard appeal against the settlement. In October 1991, the Supreme Court upheld the original $470 million settlement and dismisses any other outstanding petition. The court says that the Indian government should purchase a settlement fund and a group medical insurance policy to cover around 100,000 people who may later develop symptoms. It also directed UCC to voluntarily fund a hospital in Bhopal, and the cost of this hospital was $17 million to specifically treat the victims of Bhopal disaster. In September 2006, the Welfare Commission for Bhopal gas victim announced that all original compensation claims and revised petitions have been cleared. But again, in January, 2023, now after so many years, still this case is pending, and a petition has been signed by 40,000 survivors demanding correction to be made, because the compensation of 25,000 rupees, which is being granted to every victim, they say it was very less, and the Supreme Court should hear the petition. But on 14th March 2023, the Supreme Court dismissed this petition for enhanced compensation. So one of the many of the social movements were formulated. Many of the women's organizations, the victims organizations, and a lot of social organizations that came together, and one of such forum was Bhopal Gas Pidit Mahila Stationary Karamchari Sangh, and Rashidavi was the president of this forum, and she said that 93% of Bhopal survivors have assigned in temporary injury category. They have been only given rupees 25,000 as compensation. So the chief minister also wrote to the prime minister that injuries of Bhopal victims were permanent injuries and not temporary. But this disparity of figures and calculating the relief package, it has caused a lot of problems, and it generally shows that the activist says that it shows the insensitive approach on the part of the government. So in 1991, the local Bhopal authorities charged Anderson, who was retired in 1986, with manslaughter, a crime that carry a maximum penalty of 10 years in prison. And he was declared as a fugitive, and the Chief Judicial Magistrate of Bhopal on February 1, 1992. He says that because he has failed to appear for the hearings in a culpable homicide case, and so the government of India, they issued an order to extradite. Extradition treaty is something which is you can ask the other government to send that person over here. So Indian government has approached the United States for that, but United States declined to extradite him, citing the lack of evidence. So the US Supreme Court has also refused to hear an appeal of the decision of lower federal courts in allowing victims of disaster to seek damage in US courts. And in one of the litigation before the US federal class, in the courts under their tort law, they seek remedy for crime against humanity, because so many people are being affected, so many people are being injured, and still they are suffering the consequences of that injury. So that litigation in US court, it sought damages for personal injuries, medical monitoring, and all kind of supply of clean drinking water, and other kind of measures. But this lawsuit was dismissed in 2012, and subsequent appeal was denied. And Warren Anderson, who was, he died on 29 September 2014 when he was 92 years old. The factory was closed in 1986. The pipes, drums, and tanks were sold. And but what is happening is that there is some toxic material which is stored over there and which is falling down and spreading, and the area around the plant is being used as a dumping area for hazardous chemical. In 1982, a tube well in the vicinity of this factory has to be abandoned because the test reveals that the soil and water samples, were toxic to fishes. And in December 2008, the Madhya Pradesh High Court decided that the toxic waste should, the waste should be incinerated at Ankleshwar in Gujarat. And this was, resisted by the activists all over India. And in 2012 August, Supreme Court directed the Union and the Madhya Pradesh government to take immediate steps to disposal of toxic waste, which is lying around and inside the factories for years. The US court rejected the lawsuit blaming UCC for causing soil and water pollution around the site, and ruled any responsibility for remedial measures. So, but there are two lines of arguments which were involved in this disaster. The one is the corporate negligence, which says that disaster was caused by a potent combination of under-maintained and decaying facility, a weak attitude towards safety, untrained workforce. So these are the kind of arguments which are being taken by the victims and other people. But the UCC, the company says it blame the workers. It says the workers sabotage the plant, and otherwise it is not physically possible for the water to enter the tank without human efforts. So they blame on the employees. But a study which is conducted by the University of California in June 2023, they have found that the men who were born in 1985 within 100 kilometers of the site, during December 1984, they had 8-fold higher risk of cancer and disability than other men who were born between 1986 and 1990. And they have also shown the evidence for long-term intergenerational health effect on the of this gas leak. Their findings published in the British Medical Journal, and they have documented the health effect on people. In contrast, they have compared 4.5 kilometer radius as well as 100 kilometer radius, and they say that many people were affected, and women who are living within 100 kilometers of Bhopal, they also experienced a lot of problems in terms of reproductive abilities. So because of this aftermath of this leakage, Environmental Protection Act was brought in 1986, as the earlier speaker has also said, and it ensures that the industry shall take steps and initiative to protect the environment. And this law authorizes the central government to protect and improve the quality of the environment and reduce pollution. This is an umbrella legislation, and it determines the type of pollution. It provides safety standards, existence of various pollutant, and ban on using hazardous material. Also, other laws were also have been changed, as the earlier speaker has already spoken to. But changes have been made in Factories Act, and all kind of laws have been made. To the responsibility is now is on the industry that how it deals with the toxic material. But still, the gas leakage cases have not stopped. And in April 2023, Ludhiana city was hit by a deadly gas leak, in which 11 people were killed and 11 were hospitalized. In Visakhapatnam in Andhra Pradesh in 2020, again, the gas was leaked and many people died. In 2014, in Bhilai, in Chhattisgarh, again, the gas leakage incidents were reported. Then even in East Godavari district of Andhra Pradesh in 2014, another massive fire broke out, and because there was a blast in the underground gas pipeline maintained by Gas Authority of India Limited. In 2017, around 470 school children were hospitalized after inhaling poisonous fumes that spread due to a chemical leak at a container depot near 2 schools. in Tughlakabad area. So the gas leakage incidents have not stopped despite of laws and despite of such a long legal battle. Here I'm trying to raise questions about we have this incident happened in 1984, and in 1990s we have this policy of liberalization and privatization and globalization, LPG as they call it. This policy was introduced, and even till now we are having this discussion on Make in India and all kind of how the economy should grow. But how much we are prepared in terms of safety measures, in terms of public health, in terms of reduction of health hazards, how should toxic substances should be reduced. So if you're talking about free market policy, we're talking about capitalism, how should we take care of human health and human rights? And even if you're talking about paying compensation, can we really place a value to the human life? And if yes, then what values we are placing to human lives vis-a-vis market-oriented development? So these are the questions which I'm trying to raise here. And with this, I will just stop here. And I would also like to remind that on 14th of July, that is the next session, we have already discussed, 2 people agreed or talking about death penalty, and so 2 people have agreed. If there are more people who wanted to join, you can please join. So please let us know. So I'll stop sharing here, and yeah, so we'll just end here. Thank you.
Thank you, ma'am, for such an insightful session. First, I would like to invite Professor Vibhuti Patel for her remarks.
Thank you, Dr. Shalu Nigam, for such a detailed presentation on Bhopal gas tragedy and several tragedies after that till now, and how the environmental norms and also the norms of occupational health and safety have been violated. Factory inspector's office hardly works. We have done a number of researches, and we see that they have never been made even spot visit the way Dr. Babasaheb Ambedkar used to make when he was in the labor ministry. Even during the colonial times, he had personally gone to underground mine and seen the situation of people. And that's how he came up with such robust labor jurisprudence. But what is most important concern that we have currently is that with all such tragedies also, we are now diluting the environmental norm. I fully endorse that after LPG policy, not only India, even the China also, everywhere the environmental standards of safety, they have been compromised. So at one level, as our first speaker said, that only talk but no work. That's really true, because you meet in COP and COP26, COP20. So the COP meetings are taking place, but whatever has been the consensus, that has not been implemented by the nation states. So I think we need to really work hard. It's to shape the public opinion. We know that at various places in the country, the agitations are going on. For example, in Bombay, every Sunday citizens meet, Save Our campaign. So that kind of local level, lot of things are happening, and we need to amplify their voice. Thank you. And also the new thing that social cost benefit analysis, I think about which also we should talk in future, that what are we getting in terms of whatever industry gets in terms of benefit, but at what price, what are the people? So even people's organization, social movement, even the Satynath Sarangi, who is currently running the Sadbhavna Trust, because the government has pulled, they have washed off their hands. So it is the NGOs which is providing mental support, mental health support, counseling. Even so many people, so many the families boycott any girl from Bhopal. They said they would not marry a girl who was affected by Bhopal gas tragedy because there can be carcinogenic or mutagenic effect for the progeny. So also a lot of cultural, social, economic problems that the gas peedit people, those are facing, and that the Sadbhavna Trust is supporting them. There are a group of doctors, scientists, social workers, academicians, and research. They are also demanding that what we need to do is a social cost benefit analysis of all such big projects. And it should be mandatory for all Fortune 500 companies which are expanding their business. Business at what cost? Yeah, thank you.
Thank you, ma'am. The floor is now open for questions from the audience. Garvit Gupta, please unmute yourself and ask the question.
Yeah, I hope I'm audible.
Yes.
Yeah, I want to ask a specific aspect of how you're talking about, say, international laws, respect to free market and general capitalism. So one thing that came to mind when we cannot really have. So it measures the
Your voice is breaking. If you could please repeat the question again.
Right, can you hear me now?
Yeah.
Yes.
Yeah, so as I was saying, there was a focus on how the free market itself and its relation with environmental laws. So one thing that I was also saying in the whole debate was how we cannot fundamentally measure the value of a human being in such disasters. We can't really compensate them properly because how do we even measure how much a human being is worth in money terms? So one thing that comes to mind is that fundamentally the free market system, just by the way the recent says construction of the state itself, if the free market system in a way, it often prioritizes the short-term gains. Often short-term gains exclude climate goals and human prosperity. So, and because of the market system in itself, it tends to bring everything into a value, like it goes to value in human lives. So on some level, I see that the way the market system is functioning, it may often lead to a lot of climate problems and human development. It goes to value and weigh things that cannot be valued, say human lives and climate, say the earth itself. And we're supposed to put them up against problems. Isn't that we should have some sort of market reforms and to bring about some climate change in the world? That is clear from that.
Yeah, what I could get is that you are raising the question about the free market approach, and since voice is cracking, maybe I don't know if I have understood you right, but you're talking about the free market approach and how should we monitor that? Is that what you're asking?
Sort of, yes. Like about how the free market system itself, if it's left without regulation and control, it may often spiral out of control as it does these days. And that could be the source of the problems that we face, because what the free market forces us to do is it forces us to work in trade-offs. So how do we fundamentally value the trade-off of a life, of a human life, or climate goods or trees? And because it forces us to value something that cannot be fundamentally valued in money terms, I think that's like one of the roots of the problem of climate change and human prosperity, or the lack of human prosperity in today's society. So I was asking for your thoughts and opinions on that.
Yeah, so basically about how can the free market generally don't care about human lives, because their interest is about more in terms of profit. So even now they are talking about which I have heard of, is that even water should be privatized, even the air should be privatized. So free market is talking about profit oriented approach, but in terms of human life, that is, I think, the conscious of every citizen, every person, and even at the policy level, in terms of whether you are a judge or a lawyer or you're policy maker, you have to think about how your consciousness is working in terms of whether you want to go for the free market economy approach, okay, where profit is the only interest you're talking about in terms of 5 trillion economy, or or any other kind of these kind of measures, or you're talking about on the other hand, you're talking about the sustainable development goals, human life, you're talking about the human happiness. So there are countries like Nepal and New Zealand, they are talking about human happiness index. So these are the two kind of approaches which are there, which are prevalent. And then it's our choice, as policymakers, as lawyers, as judges, we have to choose that which side, where should we stand. So I think that is, this is what I understood, but maybe Professor Patel would like to add something more.
I think the way free market, no, there is no ethics, and just it's totally right is might is right kind of a culture, which it promotes so much, so that they want to buy countries like Ireland imagine, you don't even, the sovereignty, national sovereignty also they want to violate. So you can see that to what extent the ethics and human value and even the sovereignty of the nation state, everything gets compromised in that. And so I think the only thing is that people of the world have to come together and oppose this kind of a nefarious, and I think that the whole zombie capitalism, because they just go to any place, damage, create damage, destroy, again go to some other place, no? So right from Siberia to North Pole, everywhere they want to go and create destruction. So I think this kind of trend cannot be allowed. And I think with the continuous thread of today's discussion from very first presentation on environmental law, I think that also talks about, and nobody has mentioned our conscience keeper, women of Tehri Garhwal, who started Chipko movement, no, as a, and also against the kind of mega development projects which were coming up at Himalayas and Himalayan valleys, no, that they, and the what eco-feminists have been telling us, that you can't rape Mother Earth, no, you have to live in harmony with Mother Earth. And why only talk about human? Now all those human rights organizations are talking about living in harmony with nature, animal kingdom, plant kingdom, and the human beings. No? And that's what we saw, that even in the relief operations during pandemic, there were organizations totally working for feeding the dogs and cats and animals and flora, and see to it that because of the lockdown, nobody suffers. It's not only the human beings who have to survive on this planet, but we have to coexist with our other. So I think that approach we have to drive to the people who are powerful and who use their power or abuse their power rather for damage to the planet, damage to the animal kingdom, damage to the plural existence on this earth, and damage to the human beings.
Just a follow-up, if you don't mind, like I can tell that we've changed a lot of things in today's system, but what do you think we should do? What should we strive towards? Like more public sector, more SMEs, more like local governance, more democracy? What should we strive towards?
Amplifying the voice of local initiatives, if the way of what women did in Tehri Garhwal by Chipko movement, or what women who were fighting against nefarious activities of paper mills who were polluting air, polluting land, polluting water bodies, and also denuding the forest. They also fought Apiko movement, which was supported by the People Science movement, and so many scientists came forward in Karnataka. Similarly, Laben Bhatt and other Save Girnar campaign, which they started. Currently, so many conscious citizens of Mumbai city, they every Sunday they go and see to it that arid forest, that's the only green cover we have in this city. Otherwise, it's a jungle of cement. So that is, so I think this kind of this thing, establishing connection and also learning from the women from the environmental groups in Fiji Island or in Japan, how the Japanese human rights organization brought Minamata company, which was throwing mercury poisoning in the sea, which created carcinoma and jellyfish, birth of jellyfish baby, and big movement was created. They made a documentary, they were showing it to world community, and they brought regulations of this. So I think we have to use whatever knowledge as a scientist or engineer or architect or social scientist or researcher or journalist or media people that we have. We use our talent and bring a consensus about environmental concerns, and also like that no damage, you leave and let other people sleep. No, so that coexistence, the principle that we have to. So of course it begins wherever we are. No, we have to do this.
The whole Nyamgiri struggle, if you can read about that. So
Yeah.
it's all about the tribals who are trying to save their forest, and the kind of battles they are fighting with the corporates right now. The case came to the Supreme Court, and the Supreme Court, gave a decision in the favor of the tribal groups. But still the fight is still going on at the ground level, and a lot of activists and a lot of academics they are there to to have a kind of network to really struggle against the corporates are giants, and they have all the resources, and they hire the big lawyers, and they can invest a lot of money, but if you talk about tribals, and if you see in Chhattisgarh and other places, a lot of tribals are being incarcerated. Those who try to raise their voices are being jailed. So those kind of things are still going on, and the thing is that we need to really go out and see, and see where our conscience stand, and what we can do.
And there have been success stories also, like after the experience of Shingur and Nandigram, the bloodbath which West Bengal had, because when the local community opposed the Tata Nano. In Maharashtra, when they wanted to have, Reliance wanted to have SEZ in Sindhudurg, no, it was the local organizations, they mobilized public opinion. They did a social cost benefit analysis of what, because it's a lush green land with 3 crops, you get the best mango Alfonso from that region. People have a very good this throughout the year they are employed. There is not migration. It's a green belt of Maharashtra. And why do you want SEZ there? So the farm they demanded that we don't want any closed door meeting. Let there be public meeting in the big playground where more than 100,000 farmers could come, and let the executives of Reliance discuss publicly and put all your technology of CCTV camera and screens so that there is no underhandling or no undemocratic decision taken. And they had a public debate. Farmers asked that in what way you're going to improve the quality of life. We are happy. We get rains throughout the year. We don't have a water problem. It's a fertile land. We get so many, the best fruits of this region are produced by us, and this thing, and in what way your SEZ is going to bring this welfare for us, and what is the future which SEZ will give. And finally, they had to, and Maharashtra government also took a stand that we are not going to use repression on the innocent people. You debate, let industry and farmers who are supposed to sell who are expected to sell their land, decide through negotiation. And finally, the Reliance abandoned that plan. Similarly, government of Gujarat, they also say that government will not interfere. You will have to industry will have to directly negotiate with the people who are selling their land. If they agree, no problem. So in Kutch, they said, okay, anyway, it is desert. We don't mind Tata Nano in Kutch. So they did that. But government says, we won't use our Sam Dam Dand Bhed, like repression and threatening and blackmailing. We are not going to come in the way. It is the community and the industry, they will have to come up with the solution. And we'll see to it that community doesn't lose out in terms of their rights and their compensation and relocation and rehabilitation. All that we will see to it that their human rights are respected. But otherwise, we will not terrorize, humiliate, or intimidate community to sell off their land to the industry. So I think people have learned after Nandigram and Singhur's experience. State governments have been more responsive to this kind. Nobody wants bloodbath, no? They have to face the electorate every 5 years.
Thank you, ma'am. Now I request Professor Vibhuti Patel to give a closing remarks for the session.
I think today's discussion was extremely interesting, and it is so lively because all these issues are being fought at a ground level recently and in a post-pandemic period also. And because during the pandemic also, we saw so many natural disasters and cyclone and floods, and currently what is happening in Uttarakhand, more cracks are there, and whatever foremothers in Chipko movement had told us way back in 1972, that पौधों को बड़ा पेड़ बनाने खून पसीना पानी सींचा, पेड़ है बच्चा हमारा सच्चा, जंगल के है हमारा जीवन, उसी से पाए पानी ईंधन, पढ़ने दो ना कुलाड़ी उस पे, बहनों जग से पेट को चिपको. Now that was a very important message which they gave to the world community, and I think so many other countries in Latin America, in East Europe, even after Chernobyl disaster, so many of them have emulated that you can't damage the environment, and the Sustainable Development Goal also has given a great emphasis. So I think that was a very important 2 presentations we had today, with a very in-depth case study of Bhopal gas tragedy and its learnings. And the thing on foreign policy was so lucid, and he demystified so many notions and so many conceptual clarity also we got, and how this conceptual clarity translates into diplomacy and negotiations between the countries and at a multilateral level and at a one-to-one bilateral level. I think it is a very, all three sessions were extremely mind-boggling. They have given us a major food for thought, and I'm sure you will be also pondering over various issues which are raised, which is still a work in progress. And we all have to continuously deliberate and strive to get a sustainable development, and along with the respect for human rights and safety of the human rights. Thank you.
Thank you, ma'am. With the chair's permission, we can go for the vote of thanks.
Please. Yeah.
As we come to the end of day 13 of Law and Public Policy Youth Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course, and internship program, I, Nikita Bhardwaj, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, New Delhi. We are grateful to our expert for the day 13 session, Mr. Debadityo Sinha, Professor Swaran Singh, and Advocate Dr. Shalu Nigam, for taking out their valuable time and giving us an opportunity to learn from this online certificate program. We thank our chair, Professor Vibhuti Patel, and lead advisor, Advocate Dr. Shalu Nigam, for convening the session. We thank all of our participants who have raised pertinent questions and actively participated in today's deliberation. We look forward to welcoming you coming Wednesday, that is 14 July at 11:30 a.m. for our 14th day of this certification course by distinguished experts, Advocate Lara Jasani, Professor Anil K. Gupta, and Advocate Dr. Shalu Nigam. We are grateful if you are watching us later on YouTube or listening to us on our various podcasts or reading our publications. We hope you continue to join in future to our IMPRI #Web Policy Talk and #Web Policy Learning. Wishing you a good day. Thank you.
Thank you. Thank you, everyone.